Item number 1.
Yes, sir.
Yes.
I'll start with my lord. Page number 263, my lord.
63.
63, my lord. Sorry, my lord. 276, my lord. 276. 276, my lord.
Two seven six.
My lord. This is my lord, past recommendation, my lord, by Tender Evaluation Committee, my lord. My lord, we see here, my lord. In view of the above the price, the MS Techno Power in Enterprise, my lord, is found to be lowest as per extent. Whereas, my lord, this is their recommendation, my lord, but in term of my lord, quotation, my lord, this is not eligible. Eligible, my lord, will be by an at best, my lord. My lord, can you have a look at page 264, my lord? This is eligible one, my lord. 264, my lord. 264, my lord, will final quotation, my lord.
So it was then under that government notification.
264, my lord, can you have 264, my lord. In terms of grant, my lord, DNG, my lord, the respondent here is quoted 64 crore, my lord. Now, wind power, my lord, 54, my lord, and Techno, my lord, 61, my lord. Page number 264, my lord. 264, my lord. Grand total, my lord, will see my, which takes my lord, grand total, my lord, 264. 264 grand total, my lord. DNG, my lord, quoted, my lord, 64 crore, my lord, and 32, my lord. And wind power, my lord, the airplane, my lord, 54, my lord. And Techno, my lord, 61, my lord. Now, in terms of, my lord, simple understanding, my lord, if we give, without going to technical, suppose we inter contract with wind power, my lord, that will be beneficial, my lord, in simple language, my lord. It is it got pure, my lord. Ultimately, this is matter of public exchequer, my lord, in simple language. Now, my lord,
It's the appellate is the L1.
L1, my lord, but lowest, my lord. But past recommendation was in favor of Techno, my lord.
But then
Now, my lord,
what's the combination as per that 23 memorandum,
my lord,
18/9/2023 memorandum, the Techno, what is called? Techno Power Enterprises.
let's give pass, my lord. In past
It is found
recommendation,
to be L1.
L1.
As per the 18/9/23.
Yes, my lord.
Yes.
Now, in terms of that, my lord has
What's wrong?
thereafter, my lord,
We're supposed to follow the 18/9/2023 memorandum.
yes, that one, my lord.
Is it in terms of that?
This recommendation, my lord, yes, my lord. Now, but there, my lord has seen my 36.3 clause, my lord, in the SBD, my lord. There was a provision, my lord. The lowest bidder, my lord, need to be required some given chance, my lord, to explain his
Plus
beat match.
That's 36.2.
Two, my lord.
Yeah.
Now, applicant submit the application, my lord. Accordingly, my lord, that at page number, my lord. This is page number 306, my lord. Index number 6 was the application by the this. Undisputedly, my lord, this tender evaluation board, my lord, would have given any chance to the applicant, my lord, had made the recommendation, my lord. Accordingly, I want see, my lord, being a higher authority, my lord, he wrote this letter, my lord. At page number, this is my lord. 14/3/2024 this time, my lord. Page number 312, my lord.
306.
312, my lord. 312. Annex number 8, my lord.
This is second time, I think. Okay. Yes. Since 12 March 2024, it was rejected. It was communicated to the appellant that his
No, my lord. 306 is the this my this by the SE, my lord. Rejecting his lowest bid without any given without following the 36(2), my lord.
yes.
Accordingly, my lord, accordingly this letter, my lord, at page number 312, my 8, my lord,
Yes.
was written, my lord. He being the higher authority, he in terms of the SBD, my lord, he this letter say, my lord, this applicant needs to be give a chance, my lord, in terms of the SBD, my lord.
Yes.
Therefore, my lord, did not find any wrong in this, my lord.
Yes.
Now, my lord,
So 313 Chief Engineer
312, my lord.
has written to the Superintendent Engineer
Yes, my lord.
to submit the comparative statement.
My lord.
Yes. Then
Accordingly, my lord, not competitive stand, to give a chance to the appellant, my lord. This is
the light you are kindly request to ensure compliance with all the public problem. Yes. Okay. Then
now thereafter this he was this SC rejected his, my lord, application, my lord, price bid, my lord. Thereafter, my lord, the relevant part, my lord. Now, my lord will kindly have a 318, my lord. 318, my lord. Now, just I want to clarify, my lord.
Yes.
Later of the SE, my lord, SE, my lord, directing SE to look into his grievance, my lord, was in terms of the SBD, my lord. There is no such personal interest, my lord, but the CE, my lord. That was in terms of the SBD, my lord, as he need to be given chance under 36.2, my lord. That fact I was supposed to, I'm trying to clarify, my lord. There is no such personal interest, my lord, because, my lord, in terms of the SBD, my lord, lowest bidder, my lord, even if abnormally low, my lord, that may be given chance to satisfy, yes, he can carry out the work from that bid quoted by the him, my lord. That is the part of the SBD, my lord. So there is nothing wrong, my lord, when CE directing the SE to look into his grievance, my lord.
First, number one.
Number one.
Number one, you just show us that where is the power if the employer or for that matter the government finds that there is it's the committee or the board, tender board, if it finds that they have not done it properly or not properly evaluated the tender or the bids, the employer and the government can relook or re-examine it or re-evaluate it.
My lord, to that extent, I concede, my lord, there is no such provision here, my lord, in terms of SBD, my lord. To that extent, my lord. But the issue, my lord,
Number two, let us assuming that you may have the authority and there may not be a bar to constitute a subcommittee.
my lord.
In the previous meeting,
My lord.
when you have said that the 18 9/2023 memorandum would be adhered to, of course, in consonance with clause 36. Whether this subcommittee has taken into account of that memorandum or not.
No, my lord. That, as per the record, that was not made.
Huh?
As per the record, that was not made. Therefore,
sure?
yes, my lord. Therefore, my lord, I partially, my lord, I concede, my lord, there is no such provision, my lord, in terms of SBT, my lord, that
No, there is no, it's not been incorporated in SPD, but there's a memorandum issued by you only,
Yes, my lord.
or issued by the department or the government.
My lord.
And clearly in the previous meeting, you said this memorandum will be taken into consideration.
Yes, my lord.
Of course, subject with the consonance with section clause 36.
Yes, my lord.
Whether the subcommittee has taken into account or taken into consider the memorandum 18/9/2023.
No, my lord. My lord has seen there was series of complaints, my lord.
It's
When
okay.
we
but-
follow the memorandum of 23, my lord, that's why, my lord, this subcommittee constitute, my lord. Subcommittee constitute taking into the to look into the existing.
complaint regarding the application of 18/9/2023.
Yes, my lord.
Where it is?
If my lord will see in the in ultimate normally in this case also normally my lord has seen in term of normally it is affiliate is the L1, my lord, but when we apply, my lord, the this memorandum of 2023, my lord, now techno become L1, my lord.
It's okay.
Therefore, my lord,
So next is who?
next,
It's not your case that although the appellant was L1, wrongly or invalidly, the petitioner, Techno was given, found to be recommended
yes, my lord.
as L1. Is it your case? Is it your
No, that's why I issue what happened. When we apply this memorandum 23, my lord, in really some other, my lord, part will be L1, my lord. But when we apply, my lord, this ratio, my lord, there is a range, my lord, maximum and minimum level under 23, my lord. When you apply this, it become, my lord, other, my lord, like L2 become L1, my lord. So in such situation, there are a series of complaints, my lord. In normal understanding, suppose I offering some one some goods, my lord. If he so I want to work, engage someone in work, my lord. If suppose A, my lord, offer me, I will complete the 5, my lord, and C by 10, my lord, and D by D, my lord. Ultimately, if I offer that work to the C, my lord, A, my lord, by 5 rupees, my lord, win 5 rupees, my lord, more benefits, I will get benefit, my lord. But here is a situation who in apply, my lord, there is a series of
is it only on the basis to save the only to with an intent to save the money, or is it on viability of the project?
viability was looked into by the
Suppose-
subcommittee, my lord.
Let us assume that there may be saving of course.
Yes, my lord.
Would you expect to save the money? Would you expect any quality of work?
No, my lord, that was looked into by the committee, my lord.
That's what I'm saying.
Viability was
But
looking
that you
look
have
into
to
by.
look into when you say that when you have your own memorandum and it has been clarified in the previous meeting. We're not saying that you cannot resort it to the clause 36, right? But since you have said the memorandum 18/9/2023 will be taken into consideration in consonance with section clause 36. Why don't have you have to explain that?
Yes, my lord.
Yesterday also we put a query that is there any contradiction?
No, my lord. That's why I'm trying. My lord will see, my lord. In in this particular,
You have not applied the memorandum 18/9/2023 at all.
who apply, my lord, by the tender evaluation board committee, my lord.
No, no, by the
By the subcommittee.
subcommittee.
No, my lord.
Why you have deviated from there? That is the question, my lord. Is
Yeah, my
asking.
There was series of complaint, my lord, against that, my lord. And in reality, also, my lord is seen, my lord, the actual L1 is this appellant, my lord. But the tender evaluation committee has recommended L2, my lord. Now, there is a difference. Suppose he has quoted at the 61, my lord.
No, that we have seen. That we have seen. There is a difference. That
That is different, my lord. Now, suppose if we give the this contract to L1, ultimately there is a difference of around 7 crore, my lord. Now, that's why, my lord, it is not a singular case, my lord. There is a series of complaints from other also, my lord. That's why the government decided to have a look into this memorandum, my lord, whether this amount, my lord, by L1 can be viable in the market.
series of complaints we have brought on record.
No, my lord, not, my lord, but this in terms of this subcommittee report, which is in record, my lord, that is that can be seen there.
But that is there. But what about those complaints? Why have you brought those things on record?
My lord, the committee report itself disclose all those issues, my lord. Therefore, we did not brought that report.
Okay, let us go to the
Committee, my lord.
So you have not taken into account of the memorandum.
No, my lord, the subcommittee.
I mean, by the
There was some complaint against the memorandum. Accordingly, this subcommittee constituted, my lord, and we look in the committee have looked into the existing market value, my lord, by appointing one assistant engineer, my lord. Now, before coming to, I need to clarify two treating, my lord. Before.
let us have a look at the report once. 494.
The interest of transparency in regard to the procurement considered when section sector in the state of ownership of government of ownership of state the following of the project government made by sector under the big the waste coming committee may also be interested in similar exemption related to other package under RSS from time to time as the case in the committee is composed as well. Now, particularly this for this package, my lord, is coming, my lord. There is one writ petition also, my lord, in the petition report. Re-examination process. Committee shall examine whether the price quoted in the bid identified as abnormally low, my lord, require a justification to be sought from the relevant bidder. The committee shall examine the justification provided by the bidder for their bid. In review, this review shall include an analysis of the bid, which with respect to the subject matter, scope, relevancy, allocation of risks and responsibility, and any other relevant parameter. Therefore, my viability, my lord, market viability was the one of subject matter by this committee, my lord.
That's why we have asked you.
Yes, my lord. Therefore, my understanding of this, yes, I do, my lord, concede, my lord. There is no such I did not find any provision under this SBD, my lord, to consider this subcommittee. There, but in this type of my lord, is under out of the 226, my lord. It is a contract simpliciter, my lord. It is not a decision-making process that affect the people, my lord. As a last, my lord. This is a contract simpliciter, my lord, with the party, my lord. In such situation, my lord, whether, my lord, in a given circumstances, my lord, in a given situation, my lord, whether the government, my lord,
No.
has this alternative, that need to be only decided, my lord.
Council, we have been asking you a straightforward question. Right. Whether there was a complaint about taking into account that 23. Was there any justification that should not be taken into account?
No,
What is this?
no,
Whether you have that government or whether this subcommittee has taken it, this memorandum issued by the government has taken it off its own, or there was some issues on that. Because what we can see from the record, that it has been taken on own.
yeah, my lord. No, my lord. There is no particular complaint that, my lord, this 2023 members should not be
So
applied.
why this has been used for
This was-
examining?
This was used because, my lord,
That we have taken on own.
no, my lord, not on, my lord. My lord will see, my lord. When my
Because see, your initial tender document, when the meeting happened, another tender document, and you have specifically stated that this memorandum would be taken into
my lord,
account, right? Then this was evaluated according to that.
my
And some bidders have come low, some bidders have come low.
Right.
The lowest bidders were supposed to be given a chance under clause 36(2).
my
That is correct.
my
Now that was not given, and then justification was called for.
Right.
It's correct. Till that time, think it's correct. It was going on correct. Then what happened is a subcommittee has been formed, and what subcommittee then memorandum has been issued by you saying that that particular guideline will not be taken into account, but this re-examination will be done under this manual for procurement of goods
my
and other instructions by Department of Expenditure, Ministry of Finance. Why it has happened?
it happened when because, my lord, in this case also, my lord, actual L1, my lord, did not the is L1, my lord, in terms of this
He hasn't come. He has come
Say-
before.
my lord. Similarly, in Namsai also this happened, my lord. In Rupa also this happened, my lord. Now, in actual, my lord, L1 is different, my lord. But when we apply to the 23, my lord, this L1 become abnormally low, my lord. And he's not, he cannot be recovered. In such situation, my lord.
Was there any resolution after discussion of that thing by the government?
Yes, my lord, this,
Where is that? But is there any discussion happened within the authority saying that this cannot be taken into account because of this reasons? So we'll re-examine this bids on the basis of that. Was there any resolution that happened?
my lord, that for that I need to take instruction, but that should be there, my lord. As this was order was issued, my lord, after due approval, my lord. I believe, my lord. He said 22 March.
Okay, you carry on.
Now, second thing, my lord. Second, page number 318, my lord. 318, my lord. That 11, my lord. Page number 318. My lord, will see, my lord, this is a application, my lord, at 21, it is a representation 21, 11 to 24, my lord, by the respondent, private respondent, my lord, to the secretary, my lord. Now, top of the note, my lord, we see SNORDDS by
This is by the DC Construction.
easy construction. And RDDS, my lord. Now, accordingly, this was forwarded to the CE, SNO is the CE, my lord, forward by the secretary, my lord. Accordingly, my lord, accordingly at page number, my lord, 320, my lord, annex number 14, my lord.
Now, what is the content of this?
This content, my lord,
318, what has been written? What was their complaint?
they are saying, my lord, that, at page number 319, my lord, we humbly ask you, esteemed office, to expedite the implementation of minimum and maximum justified rate, my lord. That is 2023, my lord, or memorandum for this package. as discussed in a previous meeting and outline the speaking order issued by the chairman or board member. Furthermore, we request the due consideration be given to the union bidder who has quoted rate within the justified limit during the re-evaluation process. Now, my lord have seen this is secretary, my lord, and secretary know about this to the SNO, my lord, the chief engineer, my lord. Accordingly, my lord, this page number, at page number 320, my lord, annex number 14, my lord, was sustained by the chief engineer, my lord. I am reading this, my lord. Subject, my lord, reminder and request for re-evaluation of financial bid with implementation of minimum and maximum justified rate for the Pasigat RDTS package. Representation data sensors, with reference to the subject cited above, please find here enclosed a representation from MDDS highlighting LS discrepancy in the evaluation of the financial bid for the Pasigat RDTS package. The representation stated that the tender opening and evaluation committee under the chairmanship university recommended a bidder who quoted rate was outside the justified rates prescribed by the government. This LS oversight raised serious regarding complaints in evaluating criteria and fairness in the tender process. Such matter necessitates immediate action to ensure transparency and adherence to the guideline. In view of the above, you are requested for a detailed justification for the recommendation made by the tender opening and evaluation committee for more and for comprehensive response to facilitate further listening. Now, in terms of this, in compliance to this letter, only my lord, this private respondent was recommended, later on recommended by the tender evaluation committee. Now, I am indicating all these two letters. The case, my lord, was tried has been projected by the both sided. The authority have some interest, my lord, and that's why the solvent. It is not the case, my lord. My lord, past case, my lord, the CE wrote a letter to SE in terms of the SBT, my lord, under 36(2), my lord. They need to be given, sir, my lord. This time also CE wrote in favor of the other person, my lord, not in terms of particular person, my lord, not to the in terms of affiliate, my lord. It the respondent in SDR, this is not, he have not said initiative, but this is the action of secretary, my lord, seen by the,
They have written their letter
my lord.
after the constitution of that subcommittee and
Yes.
memorandum was issued.
Yes, my lord.
So not, this is not on the basis of their complaint that the subcommittee and
No, subcommittee has not been. I am indicating this only to clarify that there is no person interested as by the any authority, my lord. Yes, yesterday, my lord, the case was tried to project by the court from the both side, my lord, that some authority has
So
some
how
interest.
you
my lord.
reconcile? They have written a letter to the superintendent engineer for what?
Both, my lord.
We understand.
Yes, my lord.
At that point, we understand the mistake. But you are you are heading a committee.
Yes, ma'am.
subcommittee.
That I also will that my lord will find the
And then you are writing to the superintendent engineer to review and re-evaluate or re-examine it.
yes, my lord.
And the superintendent engineer is commenting the petitioner again.
Yes, my lord. That's why I'm talking about this letter was not initiated by me, my lord. Yes, there's a direction from the secretary concerned, my lord, to look into it, my lord. Accordingly, I forwarded to the
Don't you
see,
say that since the matter has been looked into by the subcommittee, how can he direct again the letter to write a letter to the superintendent engineer to re-evaluate it or re-examine it?
well, at that point of time, my lord, this committee report was submitted on 15/7.
Not a question of submitting a report. It's under seized by the subcommittee. And you are the chairman or the member of the board, I mean committee. SE is recommending in favor of on your, chief engineer's letter,
See, yes, my lord. No, that's my lord. This is
giving justification. That the committee is in favor of the petitioner.
this letter is based on
Now, the matter of re-examination is with the subcommittee. you are recommending in favor of the appellant.
But that is by decision, my lord. That's why I'm trying to indicate, my lord, this letter written in favor of this
Petitioner.
respondent, my lord,
Ah,
is not, it is in term of the direction by the secretary, my
ah.
letter
Who
representation of the
has
secretary. my-
received the memorandum of instituting the subcommittee?
uh, uh, Commissioner, my secretary.
Commissioner,
Right.
it's a commissioner,
Right.
commissioner of power.
Now, the committee report was submitted on 57/24, my lord. Now, there the government yet to call on that this committee report, my lord. And in between, my lord, this happened, my lord. This is 21/11 to 24, my lord. Is there a representation, my lord? That is simply, my lord, they need to look into it. That was the issue, my lord. Now, one issue, my lord, that he is the committee and he placed that before the committee also need to be clarified, my lord. That page number.
Is there any approval on this? What action has been taken by the government?
Yes, my lord, this is approval.
Which one?
This committee report and that is committee
Any decision on the recommendation by the chief engineers?
recommend
It's incomplete. 321. 322. Election 16. Any decision on this?
no, my lord. My lord, this letter in my epidemic opposition, also I have explained, my lord. This letter received by the CE only on 15, my lord. Before that, the government recommendation approving this subcommittee report came on 8 January, my lord. And accordingly, on 15 already LOI issue in his favor, my lord, appellate favor, my lord. This particular letter, my lord, recommending the private respondent reached to the office of the CE only on 15, my lord. That I have made a categorical statement in epidemic opposition. Now, page
Yes.
330.
You have understood what you want to present. It last to be, you are
Mind it-
only interested in protecting the your officer.
No, no, no,
There's no, I mean, personal interest. Favor someone.
they
They're
need
not interested on that. It's okay. They will just say passing of the bill. Last. Except the upside, out of 6 begin. Why you have put that awarded? Should allow only to the attendant, instead of passenger, not other categories.
that, my lord. I have in the single pens also. I have that clear by that.
Yeah.
this subcommittee reports was applied uniformly, my lord. There is not the allegation that he has applied against Pasigat only is not correct, my lord. They apply uniformly, my lord. But suppose in this case also, my lord, the techno power was the L1, my lord. But in between the pendency of this, my lord, report, this the L1 in the Rupa case also withdraw, my lord, the EMD, my lord. In Itanagar case also, my lord, they withdraw. According to the next was given, my lord. But this subcommittee, my lord, report was applied uniformly, my lord. But when, my lord, the party, my lord, who is the L1, my lord, who entitled in terms of this subcommittee report.
Abnormally low.
Yes, my lord.
They have withdrawn from
Withdrawn
the
for
process.
process, my lord. Accordingly, my lord, next was
Next
given,
one was,
my lord. There is no such, these are not applied uniformly.
there is no claim.
No claim, my lord. That was no claim. They are applied uniformly, my lord.
Where you have stated.
No, my lord, that epidemic, that come in their reply.
What they have shown, what they have given
That
is,
statement,
Whether that issue was before the single bank.
yes, my lord, that issue come in the that there is during the argument and the reply only, my lord. Their reply, my lord. That I have clarified before the learned single bench also, my lord. Not in written, but in
that
submission.
was supposed to be, as per the subcommittee report was supposed to be awarded. They have withdrawn from the
EMD,
process.
my lord.
Therefore, the next
Was given, my lord.
next was given to.
Yes,
That
No.
is your stand.
yes, my lord. And they take now, page number 330 also need to be looked at. 330, my lord, the allegation that, my lord, the CE, he himself was the subcommittee chairman, has placed this issue before the committee is not correct, my lord. My lord, you kindly have it to page 338 for movement, my lord.
338.
338, my lord. This was the note 16, my lord. This is the note 16, my lord. Page 338, my lord.
Note 16.
16, my lord.
Yes.
As per the report submitted by the superintendent engineer Pasigat, who is machine such and such, and this Pasigat package may be placed before the screening committee formed by the state government with memorandum, my lord. Now, CE, my lord, to see for Vekolingi,
338, note 16. It
16, my lord.
as suggested
Yes,
by
my
the chief engineer, which may be seen.
No, my lord, just before above that, my lord, we will see note 16, my lord. By this note only 16, it was placed before the subcommittee, my lord. The for the person, my lord, this is this is the chief engineer, my
That
lord.
is not 16, that is 15.
Oh, sorry, my lord, 15 years, my lord, 15, my lord.
15.
By this note only, this was placed before the subcommittee, my lord. Now, my lord will see, my lord, for Gecko link is the part Takum, my lord. This is depends chief engineer, my lord, part Takum, my lord. He is not the sub chairman.
He is the superintendent.
No, my lord, he is the chief engineer in other, but he is not a chairman to the subcommittee, my lord.
Okay, he is not the chairman of the subcommittee who has recommended this.
He is my
What was his,
this is my lord, part Takum, my lord, chief engineer. He is the, at that point of time, he is the chief engineer of West
then chief engineer.
my lord. So my humble submission, my lord,
One second. He was the then chief engineer who recommended.
yes, my lord. Bhartaku, my lord.
And the chairman in the subcommittee is not the same person.
Same person. He is Gekolingi, my lord. Though he is for Gekolingi here, but it is by Bhartaku.
By this superintending engineer's letter
My lord.
or recommendation is placed
My lord.
before the committee.
Committee. Accordingly, by this, not only this Pasigat package is to the subcommittee.
One more thing, well, whether the subcommittee has examined the bids of the other bidders,
Yes, my lord. So all my lord. All my lord.
including the writ petitioner and the techno.
Yes, my lord. That is a part of
All
the economy.
three, all three.
All three, my lord. Yes, my lord. Therefore, my lord, my humble submission, my lord, yes, trying to project against my lord, this officer, the department, some percentage is not correct, my lord. My humble submission.
So
Only issue, my lord, before your lordship is, my lord, in a given situation, my lord. It is not a case of this totally decision-making process that affecting the masses, my lord. It is a context implicit, my lord. When the government find, my lord, something that suppose government had made some decision, my lord, that is if during the reports the government finds some fault, my lord, that may affect the larger public interest. Whether the government has authority, my lord, to look into that, my lord. That only, I humbly believe, my lord, in a given situation, my lord, it was not in the particular case, my lord, whole looking into his, my lord, when we applied the memorandum 2023, my lord.
Small clarification. From you. See, like this 338 that has been signed by Jinko Lingia. Signed, his not signature is not there, but it's a kind of a for Jinko Lingia.
For G calling him, my lord.
The Jinko Lingia is the same person who is there in the.
Yes, my lord.
So from where you are saying that this was recommended by the earlier chief,
Yes, or it was by, for example, for Bart Taku, my lord, chief engineer, my lord. He is a Bart Taku, my lord. At that point, when this,
where is that? Where is that?
or calling a chief engineer, Bart Taku, my lord, Bart Taku, chief engineer, my lord.
Yes, sir.
Bart Taku. Bart Taku, my lord. At that point of time, when this was placed, he was,
Part of the-
yes, my lord, he was not at,
For Jinko.
yes, no, office, my lord.
Yes. Thank you. Thank you.
Therefore, my humble submission, my lord, it is, my lord, is in yes, my lord, in with looking at the other technical aspect, my lord, it was a situation, my lord, when we apply 2023, my lord, memorandum, my lord, the L1, my lord, ultimately, in real sense, if we over that to the L1, my lord, that is beneficial to the public, my lord. Now, it is not a case of single, my whole, so many, my lord, subdivision raise such issue, my lord. Accordingly, subcommittee look at whether the L1 can be given a contract looking at the market viability, my lord. But that was looking, after looking into that only, my lord, this subcommittee report was submitted, my lord, and that was duly approved by the government, my lord. So my humble submission, my lord, when there is no, even if arbitrary, my lord, in a simple sister contractor, my lord, it did not patent the arbitrary, my lord.
You could have handled it better way. You
Maybe,
mix up everything.
Maybe, my lord. That, my lord will look into, only look.
Any judgment?
It's not patently arbitrary, my lord. In this
Any
contract, like in this
Are
simple.
you relying any judgment?
No, my lord, my humble submission, my lord, when this is, it is a case, my lord, in a given situation, my lord. Normally, my lord, I do understand, my lord, we need to, I consider, my lord, in normal case, tender, my lord, is the rule book is the SBT, my lord. My, in a given, but my humble submission, in a given situation, my lord, like this, my lord.
So according to you, the 18/9/2023 is not applicable and it cannot be applied. Although you have said that it will be applied.
It was applied, my lord, in by the subcommittee, my lord.
No, finally, that's the thing.
Yeah.
What the subcommittee has applied.
Yes, my lord. No, but tender evaluation committee, my lord.
That's why, that's the case of that.
Yes, my lord.
Once it has been applied, how can you deviate or
Yes.
by forming a committee, ignore that provisions which you ought to have applied?
So my humble,
So your submission is that this 18/9 has not been applied by the subcommittee.
no. There is, my lord,
Why? When you say that it will be applied,
by applying this, my lord, when we apply this, my lord, by the subcommittee, tender board, tender committee, my lord, then the issue arise, my lord. The L1, my lord. L1, my lord, is not eligible for the.
it's not always. No, it's very clear. It's not all the time L1.
Yes, my lord.
Given.
In my lord, particular sense, my lord, if
So
so,
that indicates that you don't want to give it to the L1 because once you apply this 18/9 memorandum, it goes to the petitioner or other bidder, not to the appellant.
not to to the techno, my tech, he is not part of techno, my lord. MS
Techno is withdrawn, so you could have given it to petitioner.
petitioner. Yes, my lord. In terms of second recommendation.
That's what I'm saying.
Second
It
recommendation.
appears when we accept your submission, just because the L1 could not be given when you apply the memorandum, therefore you have not applied.
No,
So you want to give
not-
the L1.
not my lord. My lord has seen the report.
Is it your submission?
No, my lord.
Why you have not applied? I mean, why the subcommittee?
Subcommittee.
When you say that it should be applied, subject consonance with the section 33, clause 33, 36.
Subcommittee, my lord, was formed on
This is
itself. Subcommittee was formed itself to look into the decision, my lord, to apply whether that there is some wrong in wrong and
Indication of that
yes, my lord.
responsibility.
Whether there is some
Whether that is violation.
clause is
or
causes,
not.
yes, my lord. The only issue before the subcommittee whether, my lord, this, my lord, by the application of this memorandum 2023, my lord, is beneficial or not beneficial to the public.
what you are trying to infer, but then it's not clear that then page 394. Constitution of subcommittee doesn't indicate, the reference clearly says so. It talks about
Subcommittee, my lord,
procurement and clause 36, but you have not said anything on the memorandum 18.9.
my lord, that's why, my lord, I try, maybe I'm not clear. My lord will see, my lord will see, my lord, when this issue arises, my lord, when all in all subdivision, my lord, this memorandum 2023, my lord, apply, my lord, apply, my lord, the recommendation, my lord, in terms of the 2023 will be in like in L2 or in favor of L3, my lord, not in favor of L1, my lord. Like in Pasiat case, the real L1 is appellant, my lord. But by applying the memorandum 23, recommendation was made in favor of the techno, my lord, who was in real sense L2, my lord. Same issue arises before the arises in the all other division also, my
I'm
lord.
saying law is very clear. It's not necessary you should award the L1.
Yes, my lord.
The feasibility, viability, everything has to be seen.
Yes, truly, my lord.
Therefore, you could have said, I mean, clearly that since applying this, it could not have been applied because you have to see all these things. But problem is, you have clearly said to the bidders,
yes, my lord.
pre-bid meeting, that it should be applied.
Yes.
But considered section 36.
Yes.
And when you find that if it applies, the viability and other things not possible, could have said, well, committee, constituting subcommittee also that it would not be in the public interest or something like it would not be viable and all those things. But simply you just ignore.
Not in, I humbly say, my lord, not ignore, my lord, is the issue raised only by the applying this memorandum only, my lord. The issue was to decide, the issue before the subcommittee was to decide whether there's any fault in this memorandum, my lord, by applying memorandum, my lord.
First of all, uniform application of the subcommittee's recommendation. It was reiterated very categorically just now. It was uniformly applied simply because in all the cases like Techno Power, L1 withdrew. Right now, I'll show my lord, this was not the case. Just verified from the record itself. Lordship may turn to page 504. 504 of the paper book. I'll show right now.
504.
It is Rupa package. In the Rupa package, L1 was Jayant Khan. I take it Jayant Khan withdrew. No, Jayant Khan abnormally low rejected. Jayant Khan abnormally low, so rejected. Jayant Khan was L1. L1. So, my lord, if L1 was rejected being abnormally low, on the recommendation of Tender Evaluation Committee,
Rupa.
Rupa. In fact, in our chart, we have shown Jayant Khan abnormally low, rejected by TEC. Right? So, my lord, now let us turn to the recommendation of subcommittee. I take the argument of government advocate that Jayant Khan abnormally low, though found feasible by the subcommittee, but since he withdrew, it could not have been given to Jayant Khan. So if it could not be given to Jayant Khan, it ought to have gone to decontrol. Yes, L2. It was not given to decontrol. It was given to TNT, which was the highest. So this is incorrect. No, he also withdrew. He said, then only one, then
Maybe he has an instruction, no, that, what is the instruction?
here we have the office note.
D control withdraw, TT and TT also withdraw. Okay,
TTF was given the contract, but,
D control also withdrawn.
We have the office note, my lord. We have the
Whatever
office note.
joint you call. Joint account. Then lowest one, L1, D control, he is also withdrawn.
Here enterprise. My lord, no,
Sir,
we have the office note,
We have understood you, whatever you have submitted yesterday.
but here,
Yesterday you have given the.
right, but my lord,
We
here
would like,
some,
we would like to, it's a factual thing. Would like to bring them on record.
then my lord, we have the information which is contrary to their information. Right now, we have.
no, they will file an affidavit, no? They'll file an, on affidavit, they will say, they'll file a sort affidavit on the factual stuff, because we'll have to adjudicate the matter.
Then my lord, we will also give an affidavit.
Huh?
To controvert their affidavit, we will also give, we have to give our. If my lord, so far as complaints are concerned, anybody who doesn't get it is a complainant. That is the order of the day. What is so great about the complaint? One who doesn't get it will be complainant. So my lord, that is neither here nor there. Merely because there is a complaint.
No, Mr. Tiwari, we are looking into the aspect of, I mean, any partiality, correct, in these contracts. So looking into the aspect of partiality, we'll have to see like how the decision was taken and on what basis the decision was taken. That's a very material fact. Correct?
May I deal with it? Yes, it is a material fact, but if the material facts are coming out in the open, in the writ appellate proceeding, and the government advocate has got his certain new instructions, then in that very eventuality, my lord, number one, we also have a right to controvert that. If they file affidavit, we have a right to controvert their affidavit that this information is not correct. Correct position is this. That is number one. And number two, my lord, in this very case, it is not merely a question of bias or selectivity. It is much more. It is what you had promised and what did you do. Number one, the promise, the promise and the standard you had prepared for yourself to be followed. But you do not follow those very standards.
But we agree.
You deviated without any reason whatsoever. And that very deviation had no sanction of law whatsoever. These are the relevant factors to be taken into consideration.
No,
in this
this
case.
deviation, I think, it has been clarified. It should be followed, applied in consonance with section clause 36.
My lord, if I can demonstrate prima facie before the lordship that even, my lord, the 18/9/2023 memorandum can certainly be read in consonance with clause 36, then it doesn't stand to reason that you altogether prepare a new formulation.
No, that is what you are relying on. What they have done, said in the previous meeting.
Yes.
What they said, this will be applied in consonance with clause 36.
And we did it. And the authority did it. Authority applied the memorandum laying down the justification of ranges, that is 18/9/23.
We will examine it.
Number one. Number two, my lord,
Because authority has done in your favor, therefore it's correct
number one. My lord, number two, that is another important
according
aspect.
to you.
My lord, let me. I never could make my certain other aspects of submission. Well, there is another aspect. The question is, what did subcommittee take into consideration? It was, efforts were made to persuade the honorable court to take a view that the subcommittee took into consideration the CPWD manual. This is an impression sought to be created before this honorable court. Well, the answer is no.
That is the submission, yes.
That is the submission, and submission is not correct. Now let me show why submission is not correct. The committee, my lord, took into consideration, committee took into consideration, lordship, turn to page 501. I'll show what they took into consideration. 501, the first para itself. That is the principal consideration. Shri Sapte Yomcha, Assistant Engineer E of the Khamba Electric Subdivision, conducted a market survey in Kolkata. So project is in Arunachal. Man goes to Kolkata. He does a market survey.
You don't get a materials here in Arunachal, so you'll have to go there to do market survey.
But not in any case, even if somebody buys, whether contractor is buying materials from Delhi or whether from Bombay or whether from Chennai,
There is no harm in doing a market.
my lord, but then I'm sorry, my lord, there is indeed a harm. There is a harm because in a government contract, it is no longer open for authorities to send an individual to Kolkata. Over there, he will do the market survey. Now, my lord, what is the guarantee Mr. Samta Yopcha himself is honest? What kind of market survey is he doing? My lord, this is not the procedure and this is not the way government contracts are awarded. You send an individual to Kolkata, he does a market survey, he gathered the lowest X work price quotations for the identified items from the vendors, Annexure X A, and obtained quotations from several transport vendors for the transportation cost of these items from X workers to the on-road freight destination. Copies of such and such. Other documents.
Anyway, sir,
considered.
this
These
has
other
been, we have,
documents are keeping up to
we have
the members.
considered and it has been recorded or, I mean, considered by the learned single judge. We have seen it.
Yes, my lord. So that is why, my lord, this
So
is.
to now we have heard all of you because we just wanted to know the factual position, what is have happened. It's not that we have, just because they have done, this will be in their favor. It's not that. We just want to have the, you have given the list that
And
the persons who have not been, I mean, considered lowest or the abnormally low, like the appellant, has not been given the contract. Except in Pasigat, it has been given to the appellant. That is your submission. By submitting this list of,
on the basis of the
then what he is saying is no, the lowest, similarly situated like appellant in other packages, they have withdrawn from the process. Therefore, next one was given. So we just wanted to know.
yes.
He has made an order submission. We just wanted to know, is it correct or not?
Since the Lord, certain new informations have come. In the meantime, we also got some new information from this very aspect. Because there are developments and developments keep on changing because there was no finality at that very point of time. In many cases, letter of intent was given. Only in one cases there was letter of award. And there was no clarity that whether only one withdrew or other person also withdrew. Because in the meantime, other developments came to the fore that no, number two also withdrew. In that case also number two withdrew. Then here we are finding certain variations. We are finding variations to the effect that in one particular case, two did not withdraw, but they gave it to three. So there are things like that. So it is not that whatever comes out in the affidavit would be a gospel truth. It is also subject to scrutiny. This is first point I am trying to make.
We're not saying that.
Very well.
The moment they
That's
file
okay.
an affidavit, we're not saying that.
Very well.
Normally, your affidavit will assume that it's a gospel truth.
Certainly not.
Likewise, their affidavit.
It would not be a gospel truth.
If you give a false affidavit,
You know,
consequences
nobody
follow.
gives a false affidavit.
That's what I'm
It is
saying.
only that with the passage of time, when we give an affidavit, there is LOI. Passage of time, LOA comes. When the LOA comes, out of the 2-3 persons, in one particular case, second one also may go. Other package also, second one may go. Those facts may not be known to us. We only have the facts regarding the LOI and the LOA. On the basis of that, we carry out the analysis and present before the Honorable Court. Apparently, the Lord, in that very analysis, there may be changes. There may be changes subject to emergence of the new facts. That is one part of the matter. Be that as it may, my Lord. Yesterday, I think possibly from my Lord, this is the entire question had come regarding the formation of tender evaluation committee. So regarding 18923, justification of ranges office memorandum as to what exactly is the background, how this very particular memorandum came into existence, where the background of this memorandum of 18923 is in 25th August 2023, order issued on the name of the governor. This was the order issued on the name of the governor, and the background, my lord, will find is in the addendum. The covering letter, the covering thing is the order of the issued on the name of the governor. 25th August 23, my lord Justice 88 and 90, whether Governor of Arunachal Pradesh is pleased to constitute the high-level technical committee comprising of following composition. This is the composition. Now, the background of this is, Lord Chief will find this in the addendum, the very first para itself. The terms of reference, this addendum is rendered to the earlier order of meeting number such and such of the Secretariat to enable the high-level technical committee of Department of Power constituted herein with the mandate of following terms of references. One, HLTC shall study, examine, and analyze the specific areas of concerns and reasons with a special focus to determine if the abnormally low price bidding, absence of structured mechanism for mandatory pre-bidding, site inspections in the standard bid documents, and provisions of bidding by joint ventures among others could have been the potential causes or instances of extreme difficulties encountered earlier in implementation and execution of some of the important power projects and schemes in Arunachal Pradesh, which had resulted in abortive closure of some of the schemes and projects with consequential hardships, both to the project owner and many contractors. So this is the background. They found that on many occasions, they will give abnormally low bid, and then ultimately, if the contract is awarded, they will not be able to execute the contract. So with this very particular background, this committee was constituted, and the committee will not gave the report, and the memorandum then came into being, 18/9/23. So this is, my lord, the background of the memorandum. Now, my lord, so far as there were a couple of clarifications, my lord, which may be, oh, yes. But then my lord may ask this in the form of an affidavit, because we have, my lord, the response given in the RTI. Since they will give an affidavit, here we have that how many are.
Submit whatever. This regarding will not allow, no evidence required. Para 20 of the judgment has been recorded in submission. That because of the withdrawal of the EMD, etc. We will just record the submission.
Well,
Yeah,
that is the case, I
giving
did not
all
give
the-
RTI. I received an RTI.
We have heard you for 2 days.
Very well.
Now, you
Not
cannot
me.
afford to keep it.
Not two, my lord. If we go by the timing, my lord, certainly 15 minutes in my case and maybe 5 minutes today, so 20 minutes. So I have not taken that much of time by no stretch of imagination.
We
If my
request,
lord,
we request especially the learned senior lawyers. There's a more.
my lord,
Except for all the very, very important matters
oh yes,
involving the question of law and constitutional
oh
issues.
yes, yes, sir.
Here it got months together.
Oh yes,
Something and all the routine matters.
my lord,
It's basically a revenue between the.
correct. But my lord, certainly number one, I do not repeat my arguments. And number two, my lord, I do not argue unnecessary,
No, I'm not saying unnecessary. But I said,
whatever,
us-
slap.
let us devote.
Oh yes, certainly. My lord,
And without your support, it cannot be.
oh, my lord, I may even suggest Lordship may take recourse to the Brandeis brief, the American practice, that no arguments, times are allotted. Within this time, you make your submission, and thereafter,
No,
file the written arguments.
I don't have that much of the authority.
No, my Lordship
I'm
may
just
also
suggesting,
suggest
I'm just-
to my Lord the Chief Justice. In many courts, my Lord, they follow this practice.
Anything else?
My Lord, if my Lord wants clarification, I'm ready to give right now.
I think it's
Any clarification, if my Lord,
Can you give the written submission? Better, so that it is not missed out.
then my Lord, in fact,
What? They are not disputing it. There was a complaint. He said, obviously, I mean,
don't get, you will make a complaint.
yeah, so including the petitioner, including the petitioner.
The petitioner's complaint was on a different aspect altogether. The petitioner's complaint was evaluation by Tender Evaluation Committee in terms of 18/9/23 memorandum.
And one more thing,
No, other than
It's
that,
it's
there
it's
were
an
other
intra-court appeal.
Oh,
Certain-
yes.
Certain restrictions are also.
My Lord Justice Lokul, I remember, was very, very particular about it. I remember distinctly on one particular occasion, one additional document I had furnished before the writ appellate court. He straight away dismissed the old writ appeal. He said, no, I will not look into it. I refuse to look into any material.
This is what?
This is a complaint regards the violation of the order because the L1 bidder
Ah,
in many packages going to get it back.
this is by who?
This is by lots of contractors. Madam. There's the last page.
This includes DG construction.
Yes, that's what I was pointing out.
In any case, without complaints by anybody, by itself is not a good and sufficient reason because to the comment.
There is a query that comes from Lordship, so I am just pointing.
No, I was also
Yes.
asking one thing, other than that letter that is on record, writing to them for re-examination of your tender, whether you have written anything to the
Yes.
department. So this
Yes.
is where your signature is there.
No, I don't have that. It's the instruction of that.
DNG has also participated in various packages. I don't know how it works.
You have that.
Yes.
You don't have this.
No instruction on this aspect.
You can have a copy of it.
Whatever you have submitted, you share with him, and whatever he said, he has submitted, you share with him. These are documents which you have, yesterday also you have submitted 2-3.
No, but this is now, it goes out live. Parties here, and they send it on WhatsApp.
Collective signature
Yes.
is also accepted.
Yes.
That's okay.
But my submission would be in any case, complaint by itself would not justify constitution of a supplement.
Obviously, we'll go into it.
Yes, why don't we look into this matter? Why don't we see, that is what the state is trying to project. In all the packages, after all, why not it is regarding the state exchequer also. If in all the packages, the L1 bidders are being, my lord, not being awarded because of this office paper, if the government takes a decision, my lord, what is the harm, my lord? Where is the arbitrariness? That is why I'm also.
Arbitrariness lies the fact that if it is done midway or after the game is over. Here the game was over. The memorandum.
So it was replayed.
That is it. That game. But again, if the game is to be replayed, everyone has to be told about it.
Replayed with changing the rule.
Yes.
And my lord will clarify one,
All players are not there.
and Lordship,
The one who has gone is gone.
Lordship will clarify one thing, my lord.
Yes.
Yesterday, Lordship has seen, the learned senior counsel has himself clarified, the mandamus is not to award it to the petitioner.
No.
Then your Lordship will clarify, my lord.
Let us not put words in my mouth. The sentence is not. The mandamus is not to award me. The prayer is mandamus is to direct the state to act in terms of 8923 memorandum and tender evaluation committee recommendation.
That is exactly what I am saying, because your authorities may misunderstand it. The Lordship has already seen, without any exercise, the petitioner was already awarded. It has been cancelled now. That process.
Eligible bidder, not the observation
No,
of
I think observation and direction from the letter
eligible bidders.
was very, very clear.
If my lord can broaden that, man.
Eligible bidders.
My lord can broaden. Okay.
Similarly, bidder submissions are to be about for 1 week time because there are 2 other pending matters. Has been not one prayer, but not the Monday. Because Saturday, Sunday at least I'll get.
In that case,
Other
my brother will be here. Not be here. So we both this
not my Lord Justice Sanita.
will
These are the days of it's a digital world.
well
So there are ways in
we'll reserve the judgment. You submit.
My Lord Justice Kalita will be in Guwahati.
No, I'll be here next week also. Next week I'll be here.
So, my Lord, Monday, my Lord, positive.
Bench assistant.
Monday, my Lord Justice,
You headed it over to the bench assistant.
Monday.
Will not record.
Oh,
Very, this very. My Lord, on a small prayer, to my Lord Justice, 8 only. My Lord, in the election matter, I understand Lordship is possibly delivering the order. So my junior, Mr. Inchin, would be here. My Lord, because since it is for orders, my Lord, I seek my Lord forgiveness, I won't be able to. Oh, yes, 28. So orders, Mr. Inchin will be here. I'm sorry.
Mr. Didas, learned counsel, then learned senior counsel, assisted by
article.
Arthur, learned counsel for the appellate. And also had Mr. P. Tiwari, that senior counsel. Assisted by A. Sarma, learned counsel for the
One.
public writ petition and helper by learned study not for power department. This one. Hearing concluded. Judgment.
Item number 2.
Service report is awaited in this matter.
What is?
That's it.
What is this?
This is a PIL basically gossip on the aspect of conserving the.
You work it out, talk to them. You
No,
cannot be,
The
yeah, you
injury has
cannot-
already happened.
you cannot deprive either way.
Yes. So the injury
And you
otherwise.
know, it's involves a very serious,
Yes.
I mean, emotional and sentimental issue with this.
Yes, Lordship. That is true. Let the affidavit
So-
come, Lordship.
Anyway, whether you talk to your counterpart
Yes, Lordship.
and how the writ will lie against this.
Against. So it is against the inaction of the government.
What
Because-
inaction we cannot do.
Because,
That-
Lordship, may I just, because today I was not prepared for a hearing of the matter.
No,
service
it's
report
not
is
a hearing, it's not a question of
Yes.
hearing.
Lordship, just to give a bullet point on the aspect.
No,
What is-
we have read it.
So the aspect is that fundamental right protection is there for conserving our cultural rights under 29(1).
What about the others?
No, that's what I'm saying. Therefore, it has to be brought out by way of an affidavit by the government as to what they are going to do, because the injury has taken place. The injury of the deprivation of the rituals has taken place.
This will start out to be a different kind of, I mean, it
That
may have a
religious
different-
part, I'm not trying to bring
See,
it. Lord.
that's right.
I'm not trying to bring that
That
aspect.
will-
I know.
that
I know what is the
this may
the
start out to be a
larger
different
ramifications of this case. I understand. That I understand, Lord.
Try to understand.
I have also told my clients about that. There's a larger ramifications to this issue, but then at least that thing has to be looked into. Let the affidavit come, Lord. I understand. So on the next occasion, I'll.
Not only the, this side, that side it needs to also,
So that is true. I understand.
but to protect,
Yes.
not
So
one
let-
side,
let-
not one side.
I would like
Like
to.
to protect everyone.
Yes, look, I would like to submit that my case is restricted on that local incident only. I do not want to bring in the larger aspect of the religious sentiments and all those
This
aspects.
will have a ramification.
But then depriving of one class of citizen also needs to be looked into.
Unintentionally, it may get the wild part.
That while picking up the brief, I also understood where we are playing. But then the deprivation has also to be looked into, Lordship.
It's all right, that you work it out. But it's there.
Yes, I will advise my clients to work it out. I'll advise my clients to work it out. After
Heard
4 weeks,
Mr.
Lordship.
A. Sharma, learn concept for the petitioner. You Just say anything. Not
Service
say-
report is
not
awaited
say
as of
issue.
now.
There's
Service-
nothing.
Service,
Lordship.
And Mr. AMS, GAT, learned additional senior government network. Office note, no. Award service report, list after.
Can it be on 22nd of September, Lord? Obliged,
List the matter on 26. And the S spread for is the matter
22nd of September.
S spread for by Mr. S. List the matter on 26.
In the meantime, I will definitely have a talk. Obliged, Lord.
For delivery of order, item number 1.
May I please Lordship, in that case, this may be, since earlier it was listed for, cross examination of, PW one.
Today it's only for delivery.
Lordship,
Like I mentioned.
Lordship, deeply of it.
Item number 2 and 3.
Election officer of 19 Yapin ST Assembly constituency and 14 Diamond ST Assembly Council allow inspection of the documents to the applicant election petitioner. The applicant election petitioner shall also be provided with CCTV footage in respect of 24 Roa polling station in terms of the order dated 19/05/2025. IA stands disposed of. Not the copy. Only the inspection.
So, Lordship.
Yes.
I beg to mention item 11, Lordship.
Yes.
Lordship, unfortunately, I misplaced the affidavit of opposition file. So can it be taken up on 27, Lordship, next week?
On the prayer of MS and again, the council committees and that is method will be taken on 27.
Obliged. For admission.
For it.
Oh.
Do not say that we have.
It is listed for admission and today. Read, Your Lordship. I'd
Yes.
like to mention item number 24, my lord.
Yes.
And this matter may fix on 25, my lord,
Why?
because my lord,
24.
20, yes, my item 24, my lord.
Why?
Chair, my lord, there's some clarifications needed, my lord.
What is the matter?
This is regarding pay enhancement, my lord, of sub-inspector driver.
Okay. MS, have you taken?
Yes.
MS. T1 London Council, but the London State Council submits that the matter may be listed after
25th, my lord.
Lordship, then 27 years, Wednesday.
27. Then the phrase for, no, submits that she may be granted sometime as she needs to obtain certain instruction. List of prayer not being objected to by the council for the petition. Come on, let this matter be listed on 27/08/2020.
Yeah, Lordship. I
Yes.
beg to mention item number 18.
18, yes.
Leading counsel is out of station, may listed after 3 weeks.
This is listed for orders. We'll see what order.
Actually, your lordship, I don't have the file today, so it will be difficult for me to access.
If you don't have a file, don't make a mention. It is so, this file is so sacrosanct or what?
No,
So
actually,
secret or you are not
your,
shared with the
your
file?
lordship, I missed the post list today, so.
Okay. On the prayer, MS, counsel for the petitioners. That this matter be listed after
3 weeks. Your
3 weeks.
Yes.
Yes.
Yeah, your lordship. Your lordship, I beg to mention item number 14.
14.
Yes,
Yes.
I'm for the petitioner here, your lordship.
Yes.
This leading counsel is unable to appear today before this honorable court. Due to
Where,
personal
what happened to him?
Your lordship, one of his relatives has been, sudden demise of his relatives, so,
Yeah. T. Sunil,
yes, your lordship.
MS so and so, learned counsel for the learned counsel appearing on behalf of Mr. T. Sunil. Submits that Mr. Sunil is in bereavement, therefore, praise for listing of the matter after 4
Your
weeks.
lordship, 2 weeks.
2 weeks, huh? Praise the Lord, list after 4 weeks.
And your lordship, there is an interim order.
Interim order passed earlier, so continue.
Yeah.
My lordship, I
Yes,
beg to mention item number 19 on behalf of BPJ, lordship. Matter may be listed after 2 weeks.
on the prayer of so and so, learned counsel for the, let this matter be listed after 2 weeks.
2 weeks, your lordship.
Ah.
Oblige.
Item number 4.
Yes,
My lord. My lord, the petitioner is a registered firm and listed contractor of this class 5S of civil category. Here, my lord, the office of the district panchayat development officer has issued a NIT number so and so on dated 9/7/2025 for construction of Panchayat Bhavan cum CSC at Parapur Polik. And the same NIT was published on Arunachal Front newspaper on dated.
have you not submitted your bid with wax sealed envelope?
Yes, my lord.
So
The only problem that they
how
have
do you
rejected,
know you have submitted with wax sealed envelope? Was that you have submitted?
please, my lord, by reply of my representation letter on page number.
It's okay, I've seen that. You have to submit the bid
Yes, I have submitted my.
in one large wax sealed envelope, right?
Yes, madam.
And they are
But-
saying that you have not
They-
submitted it with wax sealed vertically.
Vertically, but they.
Yes, what's this, madam? It's flimsy ground. It's okay. Vertically, he said that he has submitted with the wax sealed and wax sealed envelope. What you have said is page 32, not wax sealed vertically. What does it mean? This? Wax sealed envelope is enough. Wax sealed is envelope is enough. Why is vertically or horizontally? It all appears to be very flimsy ground.
My lord, please kindly come to the page number 25, the annexure 2.
Hmm.
In NIT. there
Yes,
is-
I have seen it, page 25. Will issue notice. What can we do? No, this was, no, you see, you have said properly wax sealed envelope. Your bid was found to be not wax sealed vertically.
Yes.
Is it include not wax sealed or vertically? And it doesn't require the horizontal or vertical. Page 25. Only wax sealed.
take instruction, we'll dispose it of tomorrow. Unnecessary. Mr. Learned Counsel for the petitioner. Agreed by the rejection of this technical bid pursuant to the agreed by the rejection of the technical bid of the petitioner pursuant to the NIT dated which date of NIT
9/7/2020.
9/7/2025.
Yes.
For what?
For construction.
Construction of Panchayat Bhavan cum CSC at Parbuk dash Boli. Which district?
Dibang, Lord.
In Lower Dibangmuni district, Arunachal Pradesh. On the ground of not submitting the bid with a wet sealed envelope vertically. The present petition has been filed. The present petition is filed. Considering that the requirement of the tender, submission of tender, submission of bids in the NIT is to be in one large wax sealed envelope. This court prima facie finds that the rejection appears to be on flimsy ground. It be above MSG at the London additional senior government advocate to obtain instruction. This is the matter of tomorrow.
My lord, can you make
Tomorrow.
Item number 5.
Same,
same nature.
different contractor. Same order. But you have to obtain the instruction. Huh?
Item number 6.
Yes.
Well, the irony of this case is that without considering the case of seniors, juniors have been regularized.
But
That
issue
is-
notice.
No, there is,
You don't want us to issue notice.
no,
Well, issue notice, what's there?
well,
Consider.
I am grateful, my lord, having opined for issuance of the notice.
Yes.
My lord, at the same time, on a similarly situated case of the same department, my lord, the read petition was
There
disposed
are
of.
cases where the notice is also not deserved to be issued.
Correct.
Yes.
So, my
We
lord,
are seeking regulation of service as
at par with the juniors, the
what-
pro forma respondents, my lord.
DAEO.
District Adult Education Officer, my lord.
Okay.
The pro forma respondents, my
You
lord.
have not been regularized.
No, my lord, they are
What is your substantive post now?
junior, junior teacher, TGT,
GG.
but we were given promotion in long back, my lord, 2017. Whereas the
Illegally.
my lord, that is subject matter of scrutiny by the department. That is not under challenge nor pleaded case, my lord.
Okay.
Therefore, my lord,
We have not issued, how can they plead? They have not been given an opportunity.
no, my lord, I am making an submission
Yes.
respectfully that it is not a pleaded case. My pleaded case, my lord.
Okay.
So, my lord, these people, their private respondents, were appointed in 2021 and they were regularized in 2024 as
What?
District Adult Education Officer. my lord.
Let us, your appointment, let us see.
So, my lord will kindly have this page. No, we can. Well, kindly see page 40. One order also. 37.
Okay. It starts from this, page 37, my lord, kindly.
Appointment, your appointment.
Yes, yes. Type copy is at page 38.
Starts from page 37. How many petitioners?
4.
Uh, purely on temporary basis
Correct.
and may be reverted back to original post without assigning any reason after giving 1 month. You have not been reverted.
We have,
Still you are
we
working.
are still working.
Okay, no issue.
So, my lord, there
And
is,
then
if
how
my-
many petitioners?
we are 4.
4.
Yeah.
So same date or some different?
Yes, they're different dates.
20 November. How
Same
to
year.
obtain this appointment? 30 March, May. Huh? What is the genesis of this orders?
My lord, to be very fair,
2017,
to be very fair, to
yes,
be very fair,
you have requested the secretary.
no, my lord, the Department of Education in Arunachal Pradesh is in the eye of storm. Somehow, somewhere, the administrative laxities are there. And in the process, my lord, the longest channel. The channel has passes through. So therefore, we are also part of this. my lord.
Okay, sir. So you already were appointed on temporary basis
Correct.
from PGT to DAO, DAEO.
Yes, my lord. Starting
Ah.
from 2011,
And these private respondents, how many of them? 3.
they are 4. 3 of them.
3 or 4.
3.
They were appointed in the year 2022.
Correct. 21.
Yes.
21.
But
22, huh?
consequent upon to the appointment, officiating by order sanction. We pay.
My lord will have page 49.
They are also officiating.
They are officiating, but their services have been regularized
By who, by which order?
by order dated 24 January, page 53, my lord.
53. 21st January, 52.
Correct.
52, 53.
52, 53.
Ipa Kecha, Viri Touch,
And Tabanepa.
Taba Nepa. 24.
Correct.
This is 21.
Correct. Regularization would be both. 57, my lord. 53.
Directly appointed. 2021.
2021.
Then
Then similarly, all 3 of them. My lord will have page 74.
what is page 56?
Right.
This is a provisions in intercessional list of DA.
Yes, yes.
Then
So therefore,
you are not there.
we are not there. Therefore, we are agreed. Because you have deliberately regularized them and thereafter you have taken out us from the seniority list.
Then page
74, madam. We stands at serial number 13, 14, 15 and 16. madam. And
what is this? Under CCS PR rules, so the government of Andhra Pradesh is to grant periodical No, this is not a seniority list. This is granting of certain
Periodical
Increment.
periodical increment.
Yes. So since you are working, obviously you will be get it doesn't confer you a seniority,
Correct, correct.
right?
The final scenario,
Your simple case is that your case should be regularized.
our case should be
Police
regular.
notice.
Yes. But that,
I think you are not able to show that they are junior or senior.
Hmm.
Are you challenging their appointment?
no, my lord, we are not challenged.
Then if you are not challenging, you are not able to show that they are junior or their cases have been considered.
No, no. My lord,
What is the recruitment rule?
the recruitment rule is at page 78, my lord.
78. Yes, that will be crucial. Yes, what it says?
That's schedule 11, my lord.
Person transfer posting from senior teacher or senior most junior teacher of the department. Bachelor of Education from recognized university by transfer posting from senior most teacher, senior most junior teacher of the department possessing degree of Bachelor of Education. Are you qualified
We are qualified.
to have the Bachelor of Education from recognized university? Are you a junior teacher?
Yes, yes. TGT, my lord.
TGT is
No, my lord. That,
TGT, you are
no, no.
PRT.
no, my lord. Junior teacher has been re-designated as trained graduate teacher.
Therefore, you are PRT.
No, my lord, we are not PR.
Come to page 52, 32.
Does not speak about PRT, my lord.
Then your appointment order.
My lord,
When your appointment,
kindly come to page 20.
your appointments,
Yes, yes, yes.
SDAO.
Yes, my lord. That, no, my lord. My initial entry as TGT, junior teacher,
Where it is.
that page 20, serial number 5.
Bubakir.
Yes,
Okay, junior teacher.
correct.
Officiate a junior teacher. Are hereby appointed. See also officiate. Naba Nepa. Tabad. Larji Rigya. This is respondent petition number 1 is serial number 5.
Yes,
Then 28.
type copy is at page 29.
Anya Mili.
Yes,
PGT.
yes, we are all TGT.
Will issue notice.
But
You are not able to show that both these respondent and petitioners are, they are juniors.
no, well, kindly come. I have described in my para. Kindly come to para 5.
So according to you, they are junior to you.
Junior to me, my lord.
As a PGT or TGT?
TGT.
TGT. Well, consider.
Well,
Since you are not agreed by their state.
my lord, kindly have 1 minute indulgence to paragraph 5.
What's there?
My lord, this,
That the petitioner appointed
page
responsible as trained graduate teachers and for senior in the different university under this. Yes, certificate. Yes,
That may not be seen.
That's why we're issuing notice. Not Mr. Nitindara, that's
But
not
only
something.
one small request,
Petitioner.
pendency shall not be a bar upon the respondent authority to consider the case of the petitioner. Not only that,
Let's see. The petitioners who are a petitioner in petitioners or in numbers, who substantially, who are serving substantially as a trained graduate teacher, trained graduate teacher,
erstwhile
were
GT.
appointed as has been allowed to serve as district adult education officer.
Correct.
On temporary basis since in the year 2017. Mr. By filing this writ petition, petitioners have sought for have prayed for a direction to regularize their services in the post of district adult education officer. At par with the private respondent number
325.
325,
Performer respondent.
private respondent number 5, number 325, on the ground that the authorities have already regularized the services of the private respondents as a district adult education officer, although they are junior to the petitioners. Mr. The petitioners also prayed for a direction to conduct DPC for promotion, for regularization, and to further promotion to the higher post to the petitioners. Issue notice returning to back 4 weeks. Is who is appearing? Mr. T. Tagup, counsel for the legislating council. Enters appearance, except notice on behalf. Respondent number
1 and 2.
1 and 2. No comment. How we have copy be furnished to the event council. Respondents, petitioner and expert take a stage for service of notice of respondent. 3 to 5,
Well, they are,
3, 4, and 5.
well, they are performer.
You have not said so.
We have made in the cost title, but they are performer respondent.
Post title, you have missed it. You have not read performer. But should your party, even if they are performer, you
Fine.
take a step. Within 2 days, take a step. Next pendency of the writ petition of the bar consider the petition.
I am deeply obliged, Mr.
Spot for prices.
Item number 7.
Yes. Yes.
It's a case, my lord, even before the selection process started, they've been deprived of completing 4 part.
When is the next exam?
6 and 7.
Sir, you obtain instruction?
Yes,
What you have, how you have done it before the exam?
yes, yes.
Will issue notice? Okay. Next week, by 6th and 7th, or maybe last part of this month or first week.
Last part.
Simple affidavit, how you have to clarify how you have done it and
Yes,
what
yes.
is the,
Yes.
I mean, or and as per what.
Apparently, my lord, advertisement and the manual itself says there are large number of candidates, there will be screening them. The manual is only a written test. It is only after a written test that there is segregation. Apparent parameter appear.
And Mr. Deepak, counsel for the petitioners. The petitioners, next para, are qualified, what is that?
Candidates were qualified for.
The candidates who have qualified in the, what is it? Qualifying, what? Preliminary exams or qualifying?
Qualified.
Qualifying test,
Recruitment test.
recruitment test. Pursuant to the advertisement dated 09/05/2025. Issued by the Arunachal Pradesh Public Service Commission. For admission to the Arunachal Engineering Service Examination 2025 for filling up of 166 post of assistant engineer under various works departments in government of Arunachal Pradesh. It is the contention of the petitioner that, what is that? What is your contention?
My concern is that, madam, when before the start of the selection process, madam, on the basis of the recruitment test, qualified, you have been deprived from completing for three departments.
Okay. As they have segregated the post.
Yes.
Okay. It is the contention of the petitioner that the petitioner have been deprived for appearing in the written examination for the post of assistant engineer
Yes. In hydropower development department,
in various, should we mention it?
the three, yes, it is categorical. Result.
In what? Hydropower department,
Hydropower development,
hydropower development department,
work department,
rural works department,
and water resource department.
water resources department. As they have, as the authorities have segregated into different categories based on the departments against the, this is total 136 or what?
Yes, there are other also who are not qualified. They're civil engineers. But qualified for the department.
136. For appearing in the written examination after only after the qualifying test. That's all. The you have seen the 362 candidates who have been shortlisted twice. What is this?
That is, yes, that is also a fact. It is
So at this stage, you are not.
that is in respect of the other parties. This is the qualified candidates.
This 380,
Yes.
represent 380. This will suffice for
This
issue.
will suffice for.
For
May not be necessary.
issue notice, returnable by. Sir, we'll fix that. It's a matter of exam. Would not like to, stop the examination.
Not on the second day, maybe something.
28,
I will have
28, 28, 09, 08, 2025. As Mr.
A upon the senior council and standing council, APPSC, enters appearance. Accepted. Yeah. No private respondent. This, the, consider next period, considering that the better reverse recruitment of assistant and the written exam scheduled to be scheduled to be fixed on 6th and 7th of September, September 2025. Upon the respondents to file their response on or before the next date. Next date. They get this, right? What is here?
Here, my lord, just so my lord, this, that
60.
that's good. They have to, my lord, call for the number of posts 12 times. It comes around 1600. So, page 68. This is a result for 102 posts.
Yeah.
Of the 4 departments. Here we have 1205 candidates, my lord, 400. Very well. Then, my lord, will kindly have page 71. Here they have qualified 414. This includes, my lord, 362 who are already there at page 68. And they have doubly been included in the 71. And they have calculated it for the 12 times. That is how, my lord, candidates were just below the qualified candidates have been deprived. So these are the candidates who have got qualified, but from the answer keys are very close to the last qualified candidates.
So these petitioners are,
They have not been, they are not qualified.
they have not qualified.
But because 362 has been placed again at page 71, and for the purpose of counting 12 times, that is required to be called. They have calculated 362 twice. In the 1200 also there, 414 also there. That is how the 12 times have come.
The civil engineering and agriculture.
Yes.
In other departments, their names are also there.
Yes, the civil engineer matter at page 68, they have been named qualified only for 4 departments. So this 362% who are included in this agricultural department also, they are here also, here also. In entire, they have one of some cutoff marks, and that is how the one merit, maybe they have been placed there. But they have been placed twice. And they have to call 12 times the number of candidates for Indian examinations. Say as per their manual. So 12 times comes to 1600 something, man. So 1600 they have calculated, but then includes 362 names in both sides. That is how, my lord, 360. Additionally, could have come in.
More, had it not been
Yes.
given in these 3 departments twice, some can it go
Minimum 360 could have come.
another 360 could have been.
That's it.
qualified, made qualified. Okay, heard Mr. Okay, aspirants, candidates. And the civil, you are civil engineer.
Should.
The, having the degree of the petitioners are the having a degree of a bachelor of engineering in civil.
Yes.
It's the first one, advertisement and 9 to 5. Qualifying test.
Yes. And selected 6. Again, selecting the candidate. One. So expert dated 30/07/2025 in the civil engineering in the department of But the first one is
PWD,
Public Health, Engineering, Water Supply,
PHE, and Water Supply Department,
Urban Development,
Urban Development,
and Urban Local.
urban local bodies have been again
364 have been again placed
again placed
in the Department of Hydropower
in the
Development,
Department of Hydropower Development,
Department
Rural Works Department, and
of Flood.
Water Resource Development, which has deprived the
Candidates whose
Candidates.
marks are,
whose works are nearly
yes,
the last qualifying qualified candidates. It is the next para. That parts. Had it not select the 360 candidates in the three other departments, namely hydropower department, civil works department, and water research department, the petitioner ought to have been qualified, made qualified. The such process, that's procedure of selecting the qualified test as wants to. Has deprived the petitioners. Issue notice. Returnable, same day, returnable. Returnable by 28/08/2020. By same order. Huh? Last. Earlier, same order. So the second one, I'll need to correct something. I think it appears to be not in more than. Have you understood?
Figures are there.
We'll correct it.
Item number 8.
It's 6 and 9. No, 7 and 9. Yes.
Mayor, Your Honor. Your Honor, I have filed.
Dismiss. No repetition is maintainable. Have you read the Article 226?
I have cited one. It's no.
You read 2019 16 SCC 303. You'll get the whole law in here of the Supreme Court. No writ petition is maintainable against a private body or private person unless he perform a public duty. This excommunication is against by the society, right? Understood? Withdraw. Otherwise,
So your liberty may be given. Withdraw.
approach the
By that question.
appropriate forum. Yes. There's no bar. You may approach the civil court. You read that. Would like to argue. What judgment you are relying?
Your Honor, I am relying on Supreme Court ruling in Andi Mukta Satguru versus Dr. Rudani.
That is citation. Have you mentioned here? Which year? Huh? Forget it. You read the 2019. This from our state. There are so many. But then so that this is what? Read that, let us know. We are not saying that there cannot be a repetition against a private body.
Your
But
Honor,
then the private body, you have to show that it has been narrowed down over the time. Earlier it was not, but then narrowed down to the, but you should show that they perform public duty.
Your Honor, it's my just humble opinion. I would
Yes.
like to place before this honorable.
Yes,
Since excommunication is amounting to defamation,
it's a civil code is there,
and also it's
defamation, criminal code is there.
Your Honor, it also implies the
It's in a
fundamental right.
full-fledged, we have separate full-fledged courts, separate judiciary from executive. Excommunication, civil court, defamation, they're civil or criminal. You can.
Your Honor, on the meantime, it also implies the fundamental right of the petitioners.
But then, what is the question of fundamental right? by the, you are not, you are against the society, a private body, private individual, not against the state. Not even the authority, other authority under the state. Are you insisting, state? No. No, you. If you are insisting, we'll pass on merit, dismissing it. Let me withdraw the and Mr. But you have realized that you read this judgment. Huh? How long you are in?
No, no.
When did you join?
Nearly 3 years.
Good enough. Go through this judgment. Google it. If not, there's so many. It's all civil petition. Heard Mr. Swenson, Land Council. Your name, please?
M. Tama.
And the Land Council petitioners. Next, not heard. Mr. M. Tamalan, counsel to the petitioner. Having realized that no repetition would be maintainable against a private person in the facts and circumstances of the case, clearly submits that he may be allowed to do this petition with the liberty to approach the appropriate forum. Shared by appropriate forum. Therefore, accepted. According to the systems both the states.
Item number 10.
Yes.
So on the issue, my lord, section 21 of the General Clause Act. Last time I argued on the point that register of the society that has the power to issue the registration certificate. It also has the power to cancel the certificate, my lord. Deputy Commissioner, after holding inquiry, my lord, recommended the register of society cancel the registration certificate. And by the interim order, that it, my lord, kindly turn to page number 158.
158.
158. Now, register is saying he has taken advice from the law department, and law department has suggested that there is no provision for cancellation. Register cannot cancel. Therefore, this order has been passed saying that register doesn't have the authority. On last occasion, my lord, I have submitted one decision of decision of the three judge bench from our own court, my lord. It said, my lord, about similar matter, my lord, similar provision. And this Arunachal Pradesh Interpretation and General Clauses Act, section 30, 35 also says, my lord, the same thing, that the person who has the authority to issue, it also implies that the has authority to alter, rescind, and cancel also. Basically, this is the issue. Last occasion I submitted, my lord. Yes, my lord. Society registered by the register of firms, so under section can be cancelled by such register after registration, after affording opportunities hearing to party who may be affected. My lord. We have our own, my lord. This, Arunachal Pradesh.
my lord, the provision, we have, my lord, Arunachal Pradesh Interpretation and General Clauses Act 1982, my lord. Last time I submitted copy of that act also, my lord. Section 35. And the same provision in Assam, my lord, that interpreted, we are having that this provision also perimetry only with that provision of the Assam, my lord, that Article 21, Section 21 of the General Clauses Act is also accepted. So far, instead of Arunachal Pradesh, my lord, this,
You are what?
my lord, I am also at the president of, my lord, one organization, my lord,
What organization?
but not registered, my lord. So my case is basically like that, my lord. I am the president. I am the president of this organization who is called Arunachal Pradesh Paralympic Association. So what happened, my lord, my case basically facts, my lord. Initially, my lord, before this private respondent, we applied for the registration of the society, my lord. Thereafter, my lord, later on, what happened, my lord, when our application was kept pending, my lord, because under the, my lord, rule, the deputy commissioner is to make the verification. Thereafter, he has to send the recommendation to the register. Thereafter, register will issue the certificate. So what we found later on, that our application was kept pending for a long time, but so far the application filed by the private respondent, my lord, it was immediately, the moment it was filed, and the name is also similar, my lord, in the same name, immediately that was, my lord, recommended and granted. Then we inquired, make inquiry. Then in the process, we came to know this verification, all those things, the documents were forged and fraudulently obtained. Even this private respondent, my lord, is the president of this particular organization. He's even a government employee, my lord. So all those contention we have brought on before the deputy commissioner by filing complaint. Then inquiry was held, my lord. And after inquiry, the deputy commissioner came to the conclusion, my lord. May I take to the, my lord, recommendation of the deputy commissioner, my lord. Page 157.
Yes.
157, my lord. Now, deputy commissioner is saying, my lord, I'll just read, my lord, last paragraph, my lord. It has been found during the process of replying so post notice that two executive members of the society, namely Sri Robin Natung and Sri Sunil Dara, informed this office that there were police verification report in their name issued from police station Sagari. They also informed that both of them are from Paktikation and they did not apply for police verification from any place. If required, they will be applied from police station Paktikation, not from. So it is not there. So they asked this office to cancel the Para Employment Association of Arunachal led by Sri Navam Jams and Tenchi Sulu for their forgery and fake activities. Few of the facts is when the case is forwarded to your good office for cancellation of the registration of the society, Paralympic Association of Arunachal on technical ground as given, fill and proper. So now, my lord, we have also submitted application. Now, registrar has a duty, my lord, to consider our claim also, as well as, my lord,
Respondents association is already registered.
registered. And our case is that, my lord, before that, my lord, we applied for it. And this registration, they have falsely obtained by using the forged document. My lord. So now, my lord, this has to be decided by the registrar. My lord. This is a statutory duty is cast. Now, the registrar cannot say, because it is
Where is it? Where it is?
my lord.
The act
Section 3 of the
suppose in case there's a claims and counterclaims for one association for registration, what procedure has to be adopted? What procedure has to be adopted under the act?
let us see the act. My lord.
Find out whether in such a situation, what is there? We have understood the imperial order may not be sustained, which is just because there is no provision for cancellation. doesn't mean that he cannot cancel. That will allow, but then to resolve the issue, if there's a, one is already, I mean, it has already been registered. If you claim that it should not have been, it should be cancelled and your association has to be registered. Well, in that circumstance, what is the power and function of the, what is the power of the secretary or whatever, register, sorry. Must be provided in the rules. There is a judgment of, well, sitting in the DB, authored by this court, in respect of Manipur Registration Act.
No,
Have you come across?
now,
You just find it out. There's a judgment by this court, I mean, authored by this court in the division bench. Case from Supreme, I mean, the Manipur. Whereas there was a claim and counterclaim for registration. Olympic something association or something like that. Went up to Supreme Court, came back. Ultimately, I don't know. There, we find that clear-cut provision is given. When to apply, how to apply, when to be cancelled, what is the ground for cancellation. I mean, act with the rules. So you must be have that rules and act. Do you have the rules?
rules I don't have.
No, do you have the rules? Act, I think we have. Amended act we have. Act, do you have the act? Okay. So except to show that there is no provision for cancellation. What is the power and function when the persons applied and questions the validity of the already registered, I mean, association or certificate? What is the power of the register? How they would go. Ultimately, how to resolve it? That is more important. You
Here, my lord, society registration extension to Arunachal Pradesh Amendment Act 2008.
yes.
Here it is given, my lord, that the opportunity will be given to the parties by the registry after hearing, my lord. Then decision has to be taken. Thereafter, even appeal provision is there to the government level also.
We would like to see that.
My lord, kindly turn to my read petition on page number 107 onwards, my lord.
There's no rules as such. Three one. There shall be, what is this? What is 3-1? Page.
Page number 107, madam.
Hmm.
Upon such register main is the public such person.
no such specific rule, my lord, on that regard, my lord.
This is Amendment Act. This act we call the society is the extension to armature to this Amendment Act. It's in pub-
Since the main, this central act is the Society Registration Act, my lord.
Yeah.
And this has been extended by this amendment of Society Registration Extension or Natural Act. 2008. Now,
Your case is that the registration in the same nomenclature by the registrar is on the basis of the fake documents
my
or
first,
false documents.
my lord, first, my lord, it is something like that. If it is by this office memorandum, my lord, kindly turn to case 110, my lord. This, my lord, every application has to be recommended by the deputy commissioner. One cannot go directly to the registrar, my lord. So, we file the application before the deputy commissioner.
Where it is?
My lord will find at case number 110.
That is, where is the requirement?
My lord, 110, my lord.
110.
My lord. This is the office memorandum, my lord.
Application for registration shall be accompanied for
Fourth, my lord. Third also, my lord. In case of renewal, the DCRC will recommend the application after verifying the credential of a
It's
person.
a renewal only. We are not on renewal.
Yes, my lord, thereafter 4, my lord. No application pertaining to society registration will be entertained without the specific recommendation of the district authority. Now, we file before the deputy commissioner. Now, he also files, my lord. But he files later on, my lord. Thereafter, but my lord, now requirement is that, my lord, even before issuing the registration, my lord, the registrar has to give the notice also for hearing, my lord. This is not done in the case also. Later on, my lord,
Where is the requirement?
my lord, that requirement, my lord, will find in this 10 is number
107.
10, no, my lord, 107, my lord. Section
It's a discretion.
3 proviso, my lord. In his discretion.
Discretion.
Yes, my lord. Now, my case is like this. We file. Later on, they file. Their case was immediately considered. Our case was kept pending. Then, on our inquiry, my lord, we came to know that certain forged documents were used and our application were not considered. Then we filed complaint before the deputy commissioner. Deputy commissioner issued so cause notice to them, heard them, taken their reply on record. Then deputy commissioner made a findings. Yes, you use some forged police verification report, all those. Thereafter, he recommends to the registrar that proposing
cancel
you
it.
cancel. Now, of course, the recommendation of the deputy commissioner cannot be binding. But what I am proposing, since you have a duty to consider
By
And
hearing.
by hearing them also as well as also our applications are also pending. But I am on that point only. And thereafter take a decision. Now registrar is saying that now I don't have any power. This is only the issue. Now
Continue it. Yes.
my case.
Yes. We'll satisfy this impugn order and we'll send it to the register. The matter is pending before the register. And we'll direct them to hear the both the parties and us. Yes. 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 Okay.
That is why Malone on a good pay that I was not here. When though Malone, I was not there, but that means. But still, my lord, I have to submit. Yes, my lord, my submission will be my lord. The point I not.
No, you may make whatever submission you want. Clear, you know. Yes, you don't want to withdraw. You don't have.
Yesterday, I contacted my client, whether you have entered this kind of agreement, so he declined. So
Where is that agreement?
he forwarded me and I immediately called him and said like, then he declined. Saying that,
Who is the petitioner here?
Bogota.
Kango Taku. Techisolu is you. It's not his signature.
It's yesterday he called me. He's
In 2004.
The basis. What ground? My registration said. The first ground shown by them. Then all the document has been used by voting. With the use of this voting document, that I obtained. My team, my team is PA. His team is APA. APA versus PA, Arunachal Pradesh, Paralympic Association, and my register in this PA. Paralympic Association of Arunachal Pradesh. Now, for the basics of Alice of forgery, if all the documents were forged, this is the clear test that my lord in acquired here. This is not for this honorable court to decide whether there was forgery or not. And to this extent, my lord, the FIR was lost. And accordingly, my lord, the case was registered as FIR number 04 in 2002. And under section 468 and 471.
Yours is what? Your association is
My association is the established by Paralympic Association
Paralympic Association.
for action. Paralympic Association for
Yes.
and
Petitioners,
petitioners is APA,
Arunachal.
Arunachal Pradesh Paralympic Association. The forgery, whether there was a forgery or not, there was a, yes, it's done, and thereafter, my lord, I was. Our test has been final place, FR. So it was the duty that on the basis of a forgery document, if this had been the start matter, the case would have been different aspect, that we could have been manipulated. And my friend is supposed to bring this honorable court, before this honorable court showing that on the basis of empire that has been proved. So, my lord, my submission is that FIR forgery document has not been proved. Now, the second point is, my lord,
The decision of the deputy commissioner.
to that extent, my lord, before, I am only one. Contention of the petitioner that
they have filed their application on 26/5/2017, and that was not considered. But in this respect, my respectful submission to this report that there is no such a document, substantial document to prove this honorable court that the application in the name of Appa was filed to the deputy commissioner. Rather, my lord, now, the third point, they admitted that they have filed their application. The second application in on my lord, 1st November 2019. It is, respect my lord, I would like to read out one para, particularly probably my lord, petitioners have, my lord, that is, petitioners, my lord, it's petition or para 7, where my lord, they have stated that despite the role of consideration time period, where the members of the association found of their application for an extension has not been considered at all by the office of the deputy commissioner. They insist for the immediate action, and it was at that point of time they were asked to again resubmit the application for the extension, and saying that the short more document have to be submitted. Therefore,
Where it is, where you are
I
reading,
reading in the page number 12 of my
read petition.
There are 7. Now, next question, madam, should to be considered by the issue court is whether the region cited by the petitioner report lordship
No, we're not saying anything. We're saying that since the registrar has said that since there's no provision to cancel cancel the certificate once it is registered under the act, he could not consider. So we'll direct them to consider it. We'll not say that to cancel it.
What I'm trying to explain, madam, what I'm trying to demonstrate is a report, madam.
Yes.
There is no question from the petitioner that there was a procedural intent. To that expect,
That registrar will consider,
but,
not by us. All right.
but.
You'll be given, you'll be given opportunity. We're not commenting on that, whether it has been forged and all. Just say that it has been, this is an allegation.
Who did expect, my lord, what I'm trying to demonstrate is my lord. So for whether.
Suppose if it is found to be forged. No, if it is found to be forged or if it is not as per the documents which you have relied on for registration is found to be forged. Is the registrar has an authority to consider?
So, my lord, what I'm trying to demonstrate is that to that aspect, in order to reach to that level, my lord.
That they have to examine, they have to hear both the parties, then decide.
Yeah,
Why not directing it for cancellation?
Then after, after adopting all the procedure to obtain the registration, that has not been questioned by. And after obtaining of the registration by the file given application matter. Therefore, my submission is firstly, my lord, this is not it's to be considered. Secondly, my lord,
Yes.
there are unregistered society. I am registered society. So, no, madam, in this regard, my lord, this is unrestricted day. When unregistered society cannot, my lord, sort the relief in the name of society. My submission is that so far, my lord, APA, Jonathan Foundation, Planning Association has not registered. Still, they are on the way. Therefore, in the name of APA, they cannot sort the relief from. So, it is, understand, my lord. I have to document my lord.
It's respond number, petition number 2 is there.
My lord, that's why last time I considered, my lord, this petition number 1, I am not, my lord. Existing for petition number 1. Two.
This is unnecessary.
Last time I said.
Petition number 2 is there, whether
So, what I'm trying to say.
So, am I clear? What I am proposing is the ground of rejection that since the provision doesn't provides, I mean, there's no provision for cancellation, particular provision for cancellation of the certificate once it's registered as per the advice of the law department cannot be sustained. Therefore, this will be set aside. But then we'll send remand the matter back to the to the register cooperative societies or register of cooperative. Is it register of what?
Cooperative society, register of the society.
This is register societies, register of societies to provide an opportunity to all the for both the parties pass appropriate order. That's all.
Now, what's my lord, my extension of that.
We're not interpreting that.
That power has to be exercised by the registrar.
Yes.
But
That will direct them to consider that also. By providing opportunity.
Yes.
Representation. When did you file your affidavit? Receipt is there.
This was during the pendency of this order dated by the time. Only the
24. Then. Receipt is there. Joint Secretary.
Otherwise, my lord, this is as per the advice of this honorable court I filed. Otherwise, also, my lord, then recommendation that it be commissioner work on the basis of our complaint. So we are on the point that the commissioner or recommendation may be considered.
If a press petition is filed by the petition cancellation of registration. Yes. 26/4. When you do file your affidavit?
After take.
Where is the DC's recommendation
My lord, final date number.
for cancellation?
Yes. Kind 157, my lord.
157.
Yes. Connection 20.
Page 157 is there. Register of societies. Yes. No, they are not sick. Then we'll direct them to file the. You have already filed application
My lord,
through Deputy Commissioner.
deputy, it is pending before the deputy.
This is only for, not for registration.
My lord,
It's pending.
our application for registration is pending, my lord. And this is on the basis of we challenge this is wrongly has been
Cancellation.
issued, my lord.
Okay.
So for my lord, we are at this point, my lord, only. For our registration, there will be a different course of action.
Today, what do you want?
While
By
I
this
want,
writ
my lord,
petition.
yes, my lord, this lady is both the register. Exercise is discretion, my lord, statutory power, my lord.
That's all.
That's all, my lord.
Not for registration.
Registration, my lord, with one, my application is taking me to the deputy commissioner. Direction to the deputy. But for one day,
There's so many relief you are seeking.
that can be together heard. by the
Okay.
registrar.
Not Mr. We're sending it back. We're directing Deputy Commissioner to forward it. And the page 157, the letter communication by the Deputy Commissioner has to be considered in accordance with the law. Right? By providing an opportunity for the parties. And Mr. Arsenal answer for the petitioner. Petitioners. Petitioner.
Petitioner only, my lord.
Petitioners. We also had MSD at the London Additional Senior Government Advocate for Respondent 1, 2, 3 and 4. And 1, 2, 3. 1, 2 and 3, huh? And Mr. C. Modeland Council for respondent 4, 5, 6, 7. 4, 5 and 6. Okay. Basically, the essentially challenge made in this writ petition is to the communication that is 27/08/2021 by the Register of Societies, Government of Arunachal Pradesh, whereby the issue of cancellation of Paralympic Association of Arunachal Pradesh has been disposed of by observing that since the provision under Societies Registration Act, 1860 does not provide for cancellation of the registration, same cannot be considered. Same cannot be considered. That is page what? Where is the page?
My lord, we find page 158, my lord.
158.
Order.
Yes. Sort of unnecessary details. The HHRON, sort of unnecessary details. The petitioner, the facts, the brief facts of the case are that the petitioner is, who are you?
President,
Is the president of
Arunachal Pradesh.
Arunachal Pradesh, claims to be the president of Arunachal Pradesh. What Paralympic
Paralympic Association.
Paralympic Association. Which is yet to be registered, for which an application dated initial application,
First application, my lord, will dated 20.
application dated 20. Just give that.
26/5/2011. First application. There are the subsequent application 1,
25/11,
26/5/2017.
25/6/2017.
And the second application 1/11/2019.
01/11/2019. Before the deputy commissioner to be forwarded to the the concerned authority for its registration. Christoph. Well, in the meantime, the petitioner came to know that an association, namely Paralympic Association of Arunachal, is purportedly registered in the name of headed by the respondent number 5 and 6 as president and secretary, right? Secretary of the said association. Where is that registration?
My lord, registration.
58.
Verification, my lord, will find it is number 106.
Registration
But that is registered.
1
106, my lord.
The certificate that effect being the registration certificate. But issued by number SR oblique ITA oblique 0632 page 106, dated 24/10/2019. This is up to October 22. It has been renewed. It has been renewed.
Yes, my
Are you sure?
clear, my
It's okay. Then if it's it's okay. Keep it. We're not saying anything. Mr. Next. It is the contention of the petitioner that the registration of the respondent number 4 is based on the forged and forged documents, right? Forged documents for which an FIR was also lodged in the police station. You have lodged the FIR,
Yes, my lord. It's pending investigations.
which is still pending investigation. Since 2000? When did you lodge the FIR? The petitioner approached the deputy commissioner for recommendation for cancellation of the registration of the said Paralympic Association of Arunachal as the registration is made only made on the basis of the forged documents. Mr. On consideration of the on consideration, the deputy commissioner internal capital region by an order dated by the communication dated 09/04/2021, page 157. Has forwarded to the Register of Societies, Government of Arunachal Pradesh, for cancellation of the registration of the society, registration of respondent number 4. However, no, please. On this basis only, this imperial order has.
Yes, yes, my lord.
The next paragraph. By imperial order dated 27/08/2021, the Register of Societies has responded to the Deputy Commissioner at the Internal Capital Region the effect that since there is no express provision for cancellation of registered society on technical grounds, as highlighted by the Deputy Commissioner of Capital in the Act, the registrar may be advised to dispose of the same, informing the the that the registration cannot be cancelled, which is the approval of the commissioner within bracket law. Accordingly, the matter pertains to the matter regarding seeking cancellation of the registration of the respondent number 4 was disposed of. Next paragraph. Mr. Arsola, learned counsel for the petitioner, sir, submits that although under the, what is that act? Registration Act, which you have annexed, where you are,
Arunachal Pradesh, madam.
yes,
Pilot fight 107, madam.
107. Submits that although there is no express provision for cancellation, either in the registration of, what is registration called? The Societies Registration Act. What is that, parent act? So and so, just give the, yeah. And the society's registration within bracket extension to Arunachal Pradesh. 1860, huh? Extended to the state of Arunachal Pradesh, being the society's registration within bracket, huh? Extension to Arunachal Pradesh, bracket close, within bracket Amendment Act 2008 for cancellation of the registration. However, by application of the section 21 and section 35 of section 21 of General Clauses Act 18(1) General Clauses Act 1897, read with Arunachal Pradesh
General Clauses Act.
Interpretation and General Clauses Act 1982. Section 1 of General Clauses Act 1890 and section 25 of Arunachal Pradesh. Interpretation and General Clauses Act 1982. The Register of Societies has the power and authority to cancel your registration. He submits that the Deputy Commissioner, on careful consideration of the matter, has recommended for cancellation on the basis of the materials to the register cooperatives, the register of societies. Therefore, the register of societies has illegally rejected the cancellation merely on the ground that there is no express provision under the act by ignorance of the provisions of the law. And as such, request for a direction to the registered societies to consider the consider the case and cancel the registration of the respondent number 4 as the same has been registered fraudulently by basing on false documents. Mr. Next paragraph. Mr. Sona, Learned Council submits that as per what is that notification or communication where the deputy commissioner has to forward? Right. Page 1.
What statement?
Well referred. The communication dated 11/20/2008. The deputy commissioners of the additional deputy commission by the register of society. The Gazette amendment of society's registration extension to advanced education rules as published in the Gazette notification submits that for registration of the society no application shall be entertained without the specific recommendation of the district authority. Since the petitioner has submitted the application with requisite documents for registration for the deputy commissioner, it is incumbent upon the deputy commissioner to recommend and forward the to recommend the case of the petitioner for registration. Since the petitioner have submitted their application from time to time for registration to be recommended by the deputy commission. The deputy commission may be directed to recommend forward the same to the register of societies for registration of the association of the accordance with acted. Next paragraph. MSG at the London additional senior government advocates appearing for the respondents, state respondents. Clearly submits that although there is no express provision under the active rules for cancellation of the certificates once it is registered by the register of societies, by operation of law of the General Processes Act 1897 and the Arunachal Pradesh Interpretation and General Process Act 1980. The Register of Societies has the power and authority to consider consider case of cancellation by providing opportunity to all the affected parties. That's all. See, however, pointed out that there is no representation or letter pending before the register of societies as of today. That's what you are. No, representation, whatever the representation. Yeah, application or representation received or pending before the register of societies as of today. That's all. Then Mr. Modi, on the other hand, C. Modi, on the other hand, well, vehemently opposing the maintenance of writ petition on the ground that the petition number 1 is an unregistered society who could not have maintained the writ petition, submits that there is no proof of forgery, proof of at least forged documents for registration of the respondent number 4. Although the FIR may have been filed as of today, no concrete and there is no finding or proof of the at least forged documents. Therefore, no cancellation can be made on the basis of the mere allegations, right? It further submits that since the registration of the respondent number 4 is in the name of Paralympic Association of Arunachal Pradesh, and the petitioners associations is shown to be Arunachal Pradesh Paralympic Association, which has no resemblance or near resemblance to the association, the nomenclature of the association of the nomenclature of the respondent number 4, there would not be any bar for the authorities to consider the case of the petitioner separately without disturbing the registration of the respondent number 4. Right? That is what you are trying to say.
My line of my submission, madam,
Please tell.
or my registration was already on 24 October 2009, whereas the application of the petition was on 1st November 2009. That is my fine submission.
No.
After the registration of my society, madam, the application was denied.
They don't have that relevance. What's there?
Madam,
What they are seeking is cancellation of your on the basis of the first document, right? Well, and separately they are seeking that our association should be registered.
don't say
Because-
that.
Huh?
My registration cancel.
No. See, there are. That's why I wanted to go through those judgment. This is the authority to consider. If there is no overlapping, there can be two associations in a different name, right? But then based on the required documents, if everyone claims that I am also Paralympic, I am also, that cannot be. But if you have a different, the grounds for registration, maybe for the same purpose, you can have, there can be two associations also. There's no bar. It should not be resemblance or nearly resemblance. If there's a, it can be distinct, there can be a distinction, then there's no bar. There is no law.
That's.
Anyway, we'll record his submission.
Extra, my lord, exercise that one, whether if.
No, that's why we're sending it. That's why we're making it very, we're simplifying the matter. Let us not complicate it. All right. Should I record your submission? Even if I feel that it's not relevant. So ultimately they have to consider. Anyway, you enter. He further submits that. No, according to Mr. Modi, Learned Council, his prime submission is that the registration of the respondent number 4 was done on already completed on 24/10/2019. Where is the application? The application for of the petitioner for registration of his association is on 01/11/2019, which is much after the registration of the respondent number 4. This is the registration of the next paragraph. Resigning his submission, Mr. Arsona submits that his first application for registration was in the year 2011.
17, my lord, 26.
17.
2017.
17. And when no consideration was made by the authorities, the petitioners have to file application from time to time. The last being
It's 1/11/2019.
01/11/2000. Therefore, the application of the petitioner cannot be said to be much after the registration of the respondent number 4. Rather, it was much prior to the registration. I've considered it sufficient supply cost. Next paragraph. It is elementary of the law that every provision did not consist of express provision, as the law has to be applied. Not only one provision, but the other relevant laws involved. The registration of societies, next paragraph, is regulated by the Registration of Societies Act 1860, and for the state of Arunachal Pradesh, same has been extended by way of, where is that page? By way of the society's registration extension to Arunachal Pradesh Amendment Act 2008. Next paragraph. Another piece of the section 3 provides that section 3 of the Act of 2008 provides. Section 3 provides that filing of memorandum, other particulars, with particulars of the society. A society shall be registered In other words, the register shall certify under this head that the society is registered under the act. System. By way of, it also provides that the register may in its discretion issue public notices to such person as it thinks fit, inviting objection, if any, against the proposed registration, and consider all objection that may be received by him before registering the society. And the register may also refuse to register the society if after giving it an opportunity of showing force against such refusal is satisfied that the name of the society is identical with that of any other society previously registered under this act. Registered may refuse, inter alia may refuse. And also its objects are contrary to any other law for the timing in force. You don't have the rules, right? Except this communication. But you have the power to make rules under this 2008. It is there. No, just I'm encouraging hearing a copy of the Gazette notification. What is the Gazette notification? Must be rules must be there in the Gazette notification. There may not be rule, but then Gazette notification with this, providing all this procedure. You don't have that. Right. It says I'm enclosing you a copy of Gazette notification. Page 1110. Next paragraph. Although this is stated at the but that no rules have been framed under the Act as empowered under Section 23. The state has issued a Gazette notification which has been communicated by dated 11/11/2008 to all the Deputy Commissioner and Additional Deputy Commissioner of the districts, the state of Arunachal Pradesh, whereby it is requested to add to the procedure pertaining to the registration of societies inter alia that no application
pertaining to society's registration will be entertained without the specific recommendation of the district authority. Admittedly, the deputy commissioner, next para, eternal capital region, wide dated, wide communication dated, wide dated 9/04/2021. Has forwarded
9/4/19, well,
where this is
impugn order is 2020.
now page 157.
Yes, my lord. Sorry, my lord.
09/04/2021. After on the complaint of the petitioner. Against the private respondents. As recommended, as forwarded to the registered societies for cancellation of the registration of the society of respondent, registration of the respondent number 4, headed by the respondent 5 and 6. Mr. Also admitted position that, no, Mr. On such recommendation for cancellation, it is noticed that by an impute order dated 27/08/2021, the Register of Societies appears to have disposed of the matter on the ground that there is no provision for, there is no express provision for cancellation of registered society on technical ground. And the same appears to be based on the approval of the commissioner within the law. Making was Mr. Next, perusal of the competition that is showing so. It treats the scope that how an authority, it's a register of society, has the ignorance of the law and rather base this decision on the advice of the Department Commissioner of the law. Thereby, merely on in the absence of excess provision in a particular act or the rules, the rules, the provisions of other relevant act has been acted rules have been put on the all the stories. Not itself. Having considered that the register of societies taxpayer has not appears to have not
applied the law as it occurred to me, rather have decided by this communication to the deputy commissioner simply on the ground of merely on the ground of absence of express provision of the Registration Act. Comma. I'm of the considered view that the communication of the empty communication dated 27/08/2021 is not systemic. Another aspect of the matter we consider as per the Act, the provisions of the Act and rules, provisions of the Act, comma, once the application of memorandum is filed by a society for registration, comma, it is incumbent upon the authorities concerned to consider for registration. Mr. As per the communication dated 11/11/2018 by the Register of Societies, which provides inter alia for recommendation, which provides inter alia, comma, that no application pertaining to societies registered will be entertained without the specific recommendation of the district authority, comma. Deputy Commissioner concerned district is equally incumbent upon to act on the application of the memorandum, on the application of the petitioner. Mr. It is also advocate's position that the application of the petitioner have not been forwarded or been recommended by the Deputy Commissioner General Deputy Division to the Register of Societies as of today. Mr. Discussion made. If you know the immediate communication dated so and so, remember that 21 so and so, August 27 hours so and so, cannot be sustained. And you will get perfunctory apply the mind of the register of societies in violation of the in complete ignorance of the relevant law. The and escapable conclusion would be that the impute so and so is liable to be set as a cost. Stuff. According to the Register of
societies has completely failed to apply the law, the relevant law. It is directed that the Register of Societies Republic of Arunachal Pradesh shall examine the case of petitioner with regard to cancellation of the registration of the respondent number form by providing an opportunity to both the petitioner and respondent number 4, 5, and 6. What is it? Providing an opportunity in a period of 2 months, 1 month, you'll consider, issue notice and then consider within a period of 45 days, within a period of 45 days from today, list of from the date of receipt of the copy of this order. It is also provided that it is also directed that the Deputy Commissioner, what is called internal region, shall recommend and forward the application of the petitioner to the Register of Societies for its consideration in accordance with the applicable Act and rules. We are not considered. The people have already
During the hearing,
I want the balanced justice. I want that their cancellation should their registration should also should not be cancelled. And equally, you should also get registered.
much of it.
Geo or Zinedo.
Bibliography.
Item number 12.
The dealing council is out of station.
What is the matter? Eviction.
Yes.
You occupied what?
Lordship,
Open land.
Lordship, I haven't gone through the file.
You go through it.
just had a telephonic conversation with the learned counsel,
Who is the learned counsel?
Odugong.
Ah,
He is out of station for mediation.
one of the members
No,
prevent enforcement and demolition of government quarter. And you yourself has enforced. It's nothing. Expected. Give you some time
3 weeks.
to vacate.
No, Lordship.
Why disposing of the matter? Nothing. What's wrong is that? Let to go.
It's an admission that you have constructed it near the government quarter without any authority. ADC has given you 15 days. We'll give you 1 month. Effective. Demolish your ship. We're disposing of. Are you authorized? Have you
No.
filed the power? Have you filed power?
No.
Are you in this matter?
No, Lordship.
Well said there. Hong Kong, where is Honey?
Lordship, I have no idea.
Where is Honey? You hear Honey? Honey Tana Tara. You put in there. Many lawyers. Your name is not there.
Yes, sir, Lordship.
You will give you the copy, second copy, will dispose it tomorrow. On the prayer of Mr. So and so. Learn concept. On behalf of Mr. Can be gone. Let this matter be listed tomorrow. Are you sure?
No, Lordship.
That will be proper because he has not been, he is not power, filed the power. Because you will be dismissing his writ petition.
Lordship, 3 weeks time may be given.
Not 3 weeks. 1 week.
Okay.
1 week.
Thank you. Obliged.
Well, just exhorting because you may be in trouble.
Yes.
With this piece.
Obliged.
It may be unnecessary. Blame.
Item number 13.
Modi sir,
Petitioner here, my lord.
yes, what is this? No opposition, affidavit of opposition.
Well, opposition,
You have filed
affidavit in opposition, my lord, the deputy.
affidavit responsibility for. Who is the suit number 4? Huh?
And 5 is the deputy commissioner, man. Whether deputy commissioner will file a separate or my lord, it will relay with the respondent number 4. Otherwise, my lord, this is in this case, my lord, what the projected case is, my lord, with a limited prayer, whereby, my lord, praying for direction from this honorable court, for directing the, my lord, SP Florian to reinvestigate. My lord,
Not approach the appropriate criminal court.
since, my lord, this the matter arising out of the custodial debt. Here the petitioner is the my lord brother whose brother has been dead or is died
Are
in the
you seeking
custody.
reinvestigation?
My lord.
Are you
Because,
claiming compensation?
My lord,
It's a
well-
custodial debt.
in the custodial debt
It's
also,
a custodial debt.
my lord,
So are you seeking any compensation?
my lord.
Compensated. That is commanding the respond authority to take immediate action for reinvestigation.
My lord.
Right. Reinvestigation. How much?
Because the family is not satisfied with the investigation.
What is
My lord, who are
this is a basis of what? You to feel that who had committed suicide. Is there any provision where a person committed suicide to be provided with the compensation? You have accepted, sir.
my lord, that I have already accepted and I will skip to I will skip to this portion, my lord, for claiming of the,
No, no, it's
Since
just a question
I have
of
been-
once you have accepted that the compensation for
my lord, that compensation,
custodial suicide. So better ends there. That's the question of reinvestigation.
and what is remaining, my lord, before the lordship, praying for reinvestigation. And we are not satisfied with the investigation so far conducted by the IO of the case.
You approve
There is a sub,
the- there's any scope. But just cannot. What is this? What it has been closed. Matter has been closed. Can you not file an appropriate application before the concerned magistrate or the criminal court?
Well, so far I remember, my lord, that was before,
We'll give you a liberty. All right,
my lord.
go through the provision and file the appropriate application. But when it was the, what is the case of? Suicide case of which year?
Case of 2017, my lord.
17.
My lord.
Could have approached the criminal court at that point of time. It appears to be little, I would say, afterthought.
My lord. Since 2018, my representation has been placed before
who?
the magistrate.
Why did
Before
you approach
magistrate.
the criminal court? You have approached the wrong. How, whom you have filed an application?
Well.
Whom you have filed an application? Before whom? SP,
My lord.
police.
Before deputy commissioner, my lord.
Why you have not approached the criminal court?
As well as, my lord, deputy secretary home, my lord.
No, they cannot reopen. It is the only court. But not by us. Unless it's merely you are not, family is not satisfied. We're with you on human consideration individually, but our hands are tied. What is better withdraw and we'll give you a liberty to approach the appropriate criminal court.
My lord, I prefer to dispose of the matter, my lord. I prefer to dispose of the matter, my lord.
So cannot direct for reinvestigation. Man. Huh? Yes. Full flag. Then what is that postmortem? Postmortem report will be enough. Be sufficed. Yes. Postmortem. 69. Sixty. 75.
As per specific analysis report from Director of 0.69, where it is? What is the FSL? What the FSL? You are basing on the FSL. Yes. Because this final report, final opinion is based on the FSL. Why you are suspecting? Mr. Modi,
My lord,
why you are, what is the ground of your suspicion? Ground of your suspect?
my lord. Despite that the information was also filed by the brothers, but at the same time, my lord, there is nothing at all to be suspect that the person, diseased person could have made any suicide. Not at all any suspicion from the family that he can suicide. And
What you are saying, but postmortem clearly says so,
my lord,
strangulation, hanging.
that is the postmortem. But what would the family, my lord, consider that this should not have
Your
been?
consider will not do. You must be so something more than your consideration. Every family will feel that way. That's why I said, individual personally were with you, but then with the family, but can't help. No. Case has been closed. When did you file this writ petition?
It was 2023, man.
It was closed in 2018. Huh? And you received the compensation in 2021. Up to 2 years. Why not the provision where you can Mr. Modi, learned counsel for the petitioner submits that he may be granted some time to find out what is the relevant provisions that BNSS under shared vision. Now BNSS 2023. Under which the petitioner can approach case of present nature. Huh? Mr. I wait up
Is present. You have idea? That the senior lawyer,
My lord, I have to find out.
huh?
Item number 15.
Your Lordship.
Yes.
Lordship, Health Department was supposed to file affidavit in opposition, but till date, they have,
Oh, affidavit. Yeah. Call for the instruction.
yes,
The
Your Lordship.
instructions come.
Because this is,
MS. And you learn constitute the commissioner. Auditor, Mr. Arto, then consequent hearing on the Mr. T. Dagu, Minister for Health and Family Welfare. Health and Family Welfare. For the 3 weeks time. you have
Lordship.
to file.
Lordship, this is for the 5th occasions they are seeking adjournment, Your Lordship. So 2 weeks time, Your Lordship.
Wait.
Can I, Lordship, on 4th of September, Your Lordship, fixed date,
4th of September. But ensure that you file it.
maybe as a last chance, Your Lordship, because
It's okay. But accepted you. Not two prayer. What prayer can you pray?
of life.
Be reserved for next day.
Item number 16, 17.
Yes.
May I, my lord? My lord, this is bail application filed under section 483 of PNSS. Your lordship, my humble submission in this bail application, your lordship. Since from his arrest of accused, your lordship, he has completed 18 months, 20 days in judicial custody, which is completed almost 1 year, 7 months, your lordship. My lord, may I find the page number 15 annexure 2 of our petition. Your lordship, that is arrest and forwarding report of the accused, your lordship.
Yes.
And your lordship, in this petition, in this forwarding report, your lordship, at the time of his arrest, as per the arrest memo, which is,
No
And-
ground is,
yes, your lordship,
no, there's no ground of arrest.
yes, your lordship.
Yes.
And lordship, annexure 3, page number 16 of our petition, my lord, no any ground of arrest, your lordship, and reason, Or arrest of-
Annexure 3,
annexure 3, page number 16, your lordship, our petition.
arrest memo.
Yes, lordship. And my lord, that the IO of this case has completely violated the mandatory provision of section 50 CRPC, your lordship.
Okay, we have heard that other thing. Any new ground?
Your lordship, this is technical ground, your lordship. Your lordship, in this instant bail application, it's depend on technical issue. Like the violations of section 47 and 48, your lordship. My lord, this ground prevail even after the charge sheet of this case.
During
On-
the trial also.
Yes, your lordship.
At the faggot of the trial also.
Yeah, lordship.
Show us.
Yes, lordship.
Show us.
Trial, your lordship.
No, so that you show us that these grounds also prevail.
Yes,
Even at the faggot of trial
trial of the case
or
observed.
during the trial.
Your lordship, oh, okay. Your lordship, Honorable Apex Court of Case Byan Kumar versus State of Haryana, lordship. May I so, sir?
Say.
My lord.
Say. Where it has been said,
Yes, lordship.
these grounds will also prevail, will continue to be a ground for granting of bail,
Yes.
for grant of bail during the trial and the flagrant of the trial. So where is that?
Your Lordship, in Bihan Kumar, State of Haryana versus Bihan Kumar versus State of Haryana.
You read
Your-
the relevant paragraph.
Yes, Lordship.
Read it.
Lordship, paragraph 9, Your Lordship.
Yes.
Paragraph page number 7.
What does it say? Read it, please.
Okay, Your Lordship.
Why you are smiling? You
Your
are
Lordship.
giving a bail application.
Yes,
And
Lordship.
behind it is in custody. for
Yes, Lordship.
Nearly 2 years. Why you
Actually,
are smiling?
Your Lordship, this is my first bail application hearing, Your Lordship. That's why.
That's why we're hearing you.
Okay,
That
Your
is
Lordship.
second or first.
Your Lordship, paragraph paragraph 9 of last stanza, Your Lordship.
It's good that you should have a habit of smiling.
No, my Lord.
Have a smiling face.
Your Lordship, section 50 of CRPC, read with section 47 PNSS. Person arrested to be informed of ground of arrest and right to bail, Your Lordship. In subclause 1, every police officer or other person arresting any person without warrant shall forthwith communicate to him full particular of the offense of which he is arrested or other ground of such arrest, Your Lordship.
Yes.
And Your Lordship, in recently order passed in our Guwahati High Court, Your Honor of this court, Your Lordship. Taken by our Honorable High Court while deciding many bail applications in this heinous offense like POCSO and NDPS cases, Your Lordship. In Your Lordship, order of Srimati Soika Sokia, bail application case number 34/2025, Guwahati High Court of this Your Honor Court, Your Lordship. In page 5, paragraph number 10, Your Lordship.
Is NDPS
Yes, Lordship. In
present case is what?
present case is Your Lordship POCSO.
So
My Lord, in this case, Your Lordship, commercial quantity, this Honorable Court grant bail, Your Lordship. Your Lordship, paragraph 10, Your Lordship. May I read, Your Lordship? The accused was arrested on 10/01/2024 along with 3 other accused persons, and thereafter he was furnished with the arrest cum inspection memo, Your Lordship. Parcel of arrest cum inspection memo furnished to accused as well as intimations of arrest under section 47 of PNSS 2023 does not disclose the ground of arrest, Your Lordship. The checklist which was been sought by this court to the additional public prosecutor also recorded the ground of arrest, but the same admitted has been furnished to the accused, Your Lordship. And Your Lordship, in another bail application number 02/2025, my Lord, now in this bail application, I had prepared the entire materials, including the ground of arrest and inspection memo of the accused. Memo of the accused, Your Lordship, wherein Your Honor Court may find complete violation of section 47 and 48 of the NSS, Your Lordship.
where does it say that when you're reading that it also so relevant at it during the time of trial
Yes, Lord.
or the faggot of the trial? To show that we understand what a ground of arrest has to be, but same 03 of that 2024 case. 03. PS case 03.
Yes, Lord.
PS case 03.
Yes, Lord.
We have already rejected the co-accused. What do you say? No. Simply their ground is that the ground of arrest has not been furnished. This will, I'm of the privacy, I mean, tentative view that second of trial. But how many witnesses have been examined?
Your, in this case, your lordship, 10 examined, 10 witness.
Total 15. Total 15. PW. So what do you say? That's what I'm saying. The simple ground in this bail application is that grounds of arrest had not been purchased. That's all. It is relying on the So now at this stage, other than this ground may not be that relevant. That's why I'm asking. What do you say? Frankly, I need your assistance. Whether these grounds of arrest, it should be at the initial or the best. The initial opportunity and opportune time. But related with these things about the trial is on, charge it has already been filed. Now, this may not be that relevant. But if you have other, although there you have not said anything, needed anything, but if you have any other ground, you may argue. Other That's the reason we're keeping it, fixing it again and again. Where is Munna?
Actually, your
Munna Kumar
he
Singh.
is not present today, your lordship.
Was there
Yeah,
for some time. He was here for some time. I told you to come, ask him, request him to come.
I inform him, sir, lordship. But
It's okay. We'll pass the order. Well, we'll see. Reject it. But one thing, why he should be here for nearly said you have examined 10 witnesses already. There is a chance of even if he's convicted, he may plea. That is the one friction. Can we direct them? Direct the used to apply before the special judge. He may know better whether he's required to be. That we can direct because we don't know. This ground is only for the non-producing of. We'll explain that. Whatever is there. As you said, would clarify that may not be relevant at this stage because of the trial that get what we tried. But then we'll give a liberty to approach to the. Can I do that? Do I have the? No, we can say that because they may say that once the High Court, in case we reject it, MSA they close that door. I mean, doors are closed. Yes, because it's been nearly 2 years. It's again. We'll see. We'll see pass the order. Heard, Mr.
K. Moses Johnson.
Your name will be recorded.
Yes,
J. Moses.
yes, Lordship.
Good to see you smiling all the time since from the beginning.
Thank you,
Keep
sir.
it up.
Thank you, Lordship.
You can. And Mr. Here. MS Dangan for legal aid counsel for respondent. Informant of the victim. Let's say informant of the victim. And whatever. You are for 2 and 3. 2 and 3 and 4 respondent. Somebody. Pass the order.
Deeply obliged.
साहब आप बोलता है तो देख लेना सब ओके
Much obliged.
Item number 20.
The IA is a contempt petition, Lordship. It is contempt petition, we have filed one IA.
This yes.
Lordship,
IA is for what?
IA is for implement
Yeah.
of the
And-
incumbent officer, who is the contempt number, would be contempt number 2.
Why?
Since contempt number 1 has been transferred out,
Okay.
so in his place, the respondent.
Will allow? And Mr. J. Jini. Heard Mr. J. Jini done counsel to the applicant and also heard Mr. M. Kato. Applicant and then counsel for respondent. Number 1. Respondent, we'll say respondents. Respondent. What is right? Applicants, Next, whether this is an application praying for implement of 10 above Navy commanding officer, page 1, 11 RCC. Within bracket GREF, 1116 Road Construction Company. As respond number 2 in the connected content case number 07 AP of 2025. Next one. I have considered the application. Next one. Where is the application? Consider submissions of the possible applicants and also perusal of transport. treatment. It is. They are not being objective to a concept of this. Exponent number?
One.
It's content number one. Is the observe. So is reported been posted. City away is trying to give the love to be completed. As respondent number two. So they can connect with them.
The main case, Lordship,
Petitioners to next para in contempt petition. You contempt petition, petitioners to file and post likely. Please speak to purport the name of the duly indicated. You said in terms of the order, three of the order part in the ISO. But it's not the file method of that is the registry to incorporate. Daily. Then there of course petitioner will take steps.
already they are representing, Lord.
Huh?
Already they are representing. They are.
Okay, then check it. Since Mr. For respond what, comma. Notice. For respond, needed respond number two. Therefore, comment notice is wait. This is the method after
1 week, Lordship.
2 weeks, 1 week. To take instruction. It's a contempt. Just ask them whether you compliant or not.
Lordship, in fact,
Compliant will initiate.
Lordship, in
If
fact,
it
they
is
have,
compliant, whether this clause,
Lordship, in fact, they have filed their affidavit in opposition, Lordship.
saying what? We have not complied.
Lordship, they are alleging certain thing, Lordship, but then in their
It's
affidavit,
okay, we'll see. After a while.
after a week of life.
Item number 21.
Yes.
File Lordship, for certain modification in the interim protection order previously passed Lordship, on court.
Why?
Because Lordship, I have been released by the incompetent authority. Whereas, and that too from the previous, not from the present.
Why you are after, it is the
Kindly-
transfer order
Yes, kindly see
of
Lordship,
what? Teacher.
teacher, ATV, I am a physically, personally disabled. Lordship, kindly see, that has been already on the previous occasion, Lordship.
Yes, so what is what modification is there?
Lordship, after receiving the court order on 8th of July, the authority was telling me that you will be released. But later on, I have been informed that I have been already released on 2. Whereas on 2, it was already on court order has been passed on 4.
You said that you have not been released. Therefore, we said the petitioner
Yeah.
had not been released if
I was
already
I
not
was-
released.
I was not released.
Huh?
When court order was received, they have manipulated the procedure, saying that you have been released on 2. This is the issue here. Lordship, there was a In the
How
court
do,
order,
how do
the
you,
interim- interim order itself, there is the scope of modification. So later on, after receiving, they have said, no, you have been already released.
see, you have said that on that day when the metro was moved, that you have not been released.
I
I
was
know
not
that
re-
day.
I was not.
On when? On, so that question, if you have not been released, you should.
Part or two.
No, this,
Hearing was done on 4.
yeah,
And
then
I
if
have
you are,
no-
if you are released on second, how can
I have-
you?
I have been shown on release on 2. That is it. And whereas I was not released, I had a communication with the authority on 8 of July, saying that I was yet to be released. But this CRCC is not a competent authority to release as per the rule level of education rule.
Therefore, there is not a case for modification. You file an additional affidavit. If you say that,
Lordship, this is a prayer. Because in prayer, this is my prayer.
we cannot
In
modify this. Sir, it's difficult to modify.
If it is Lordship, since I have been already released, even if the releasing authority is not completed, then I have to suffer a lot. Since my service book will be out.
No,
And
problem is you have been released before 4th of July.
Yeah, July 4 hearing was done on, I have been shown to be released on 2.
Then what can we do? That's why that day on 4th you said I have not been released.
Whereas I was not released. That is the issue. That is one of my part of argument. And
So what to do? If how do you determine?
my second line of argument is Lordship, this CRC is not the competent authority. to
You
release.
file an appropriate application,
Uh,
additional affidavit. Heard Mr. T. Tapak, London Counsel for the petitioner. By filing this application, the petitioner has sought for a modification. Okay. So you may continue. Call. Running short of time, call them.
I am to say no. That's for the rule level council. Because the school, there is a serious defect in the transfer order. Because, kindly see, on 26 on merit also, kindly see, on 25 May,
Merit we are not going to now.
yes,
It's listed for orders. You have
I-
filed an IA for modification.
yes.
What kind of modification?
Modification, Lordship saying that I may not be released till hearing of the.
How can we then, you say that on your submission, we said you should not be released if not already released. This has been consciously passed. You said you have not been released. Therefore, we said if you have not released, don't release.
That is why, Lordship.
Now
that-
you have released, you have been released even on second, 2 days prior to this order.
my part of argument is not. Even if I am released, Lordship, the releasing authority is not competent to release. Lordship. As per
So-
the rule.
That is, that
is-
ground
that is- that is
ground
ground.
you have taken in the writ petition.
Not at that point of time, I was not released. Now I came to know.
Therefore, you
I have-
file an additional affidavit challenging that,
uh,
challenging that.
I may be allowed to Lordship on that next day, pray this prayer, Lordship. Since writ petition part, I have made a prayer for stay. But in the previous order, there is no stay order. Stay was conditional, saying that if I am not released from the establishment.
Sir,
That is why, Lord.
sir, we cannot grant you whatever you ask for. After hearing you, we pass the order. It's not one-way traffic. We'll have to balance both we'll have to do a justice to both the parties. Right? Just because you are asking will not be on the drop of a hat, we don't grant prayer.
I can file additional affidavit, that is not an issue, but Lordship, well, no relief is there that I have to suffer. Since I am a physically person with handicap,
Can't help it. We have passed an detailed order. Therefore, you said that you have not been released. Therefore, we said
Admittedly, I was,
you should be released. Considering your submission only, we have allowed.
I was,
Granted this.
admittedly, I was not released.
Therefore, question of today, the question of, there is no question of modification of this order. If you are agreed, you may file appeal. Appropriate.
Matter may be disposed of.
No, today we cannot.
There is no case, Lord.
If there is no case, you withdraw it. Where should? At the appropriate stage. See, how can I modify? This order was passed after hearing you.
Lordship,
Rather,
my content,
either you have tried, you have misled this court that you have not been released.
Lordship, my,
See, it's, I said, I've indicated, sir, it's not one-way traffic. You have to be very careful.
my, as per my apartment,
It's not question, how do you, how, your abhorrent cannot be accepted all the time.
but that is a fact, what I have submitted.
So what can we do?
On 8,
On your
8,
submission, we said you should not be released if not already released.
that is why,
Now they say, you are saying that they have been released prior to 2 days prior to that. It's a question of modification.
that is the argument of the department side, saying that we have been already released. That is why I am submitting,
So why you
That-
have filed this application?
person-
Is it
the
a
per-
ground for modification?
yes,
How?
ground is that on 8, I was not released. Till 8 of July, I was not released from the establishment. Number 1. Number 2 is, I have not been released from the school where I have been posted. That is the issue. Two issues there. I cannot be released from the another school.
Don't know.
That is the issue here.
At Mr. T. Tapak, then council goes. This is an application for modification of the order dated 04/07/2025. On the ground that the petitioner has been has sought to have been released 2 days prior to the order dated 04/07/2025. Taking issue notice returnable by 4 weeks. List after 4 weeks. So make it.
I may be allowed to file additional appeal. Saying that,
It's always there. The petitioner may file affidavit, additional affidavit.
Can this matter be fixed for tomorrow, Lordship? Saying that if there is a instruction from my client, because there is a pressure saying that on the next that I will not get salary since I have been reading. I will
So
press for withdrawal of
you better go. Better go. You are a teacher.
matter may be fixed for tomorrow, Lordship.
Better
I will-
go. Better, you are a teacher.
Yes, ATV. That is the person who, ATA is. If there is no reading, there is no question of.
Mr. Tapak, you are a seasoned lawyer. Don't be too emotional. Don't argue the matter
Fix for tomorrow.
on emotional sentimental issue.
I will seek instruction from my client for withdrawal of the case.
No.
That time.
Okay, this on Friday. Yes. You seems to be so, dejected today.
But exactly not.
You are just the opposite. We have seen a lawyer who since the inception he was smiling. You are just the opposite.
Lordship, when there is a.
We feel safe when the lawyer is not smiling.
Lordship, there is a manipulation of the court order. What is this court, honorable court?
Manipulation of the court's order.
Yes,
What do you say? What do you mean by that?
my argument is, Lordship, there is an authority has manipulated this court process. Lordship. Since I have submitted the court order on 7.
You file an application, we'll see. will cause an inquiry.
There is no
Appropriate just cannot be accepted on your submission. If you seriously alleging that, file an application.
very serious law.
You file an application, we'll consider. Simply don't use the word, it's manipulation, it's a very
Manipulation is I have been told, Lord. On 8th, there was he was not released. When on 8th July, he was not released, how he can be released on 2?
Okay.
Impossible.
Thank you.
That is my submission.
List the matter on Friday.
Yes, very on top.
29. Item number 22.
Yes.
So Lordship kindly peruses the last order. Right.
Affidavit is
No, they were supposed to get instruction. This is a case, my lord.
Yes. What is this?
My lord,
What is the
kindly have
matter?
page 39, my lord, for a moment. Page 39. Our Baiba Muse was postponed along with the senior personal assistant. My lord, kindly have page 39.
So, madam,
Interview has been held, right?
tomorrow.
No, my lord. What is there, my lord? More than a month. When the similarly situated person by the same order, whose interview also was postponed, they've already held it.
Senior assistant.
Yes, yes.
See, it's single bench is or so far as the personal.
That's expected.
No. But by this page 39, they have postponed SI and the personal assistant.
Of records, whatever is available. Yes, it's 100% fair.
Yeah.
No instruction from the,
So that's why that's why we call for an instruction.
yes,
We don't want to pass any order without instruction.
now this officer, all the officers have to be there. Therefore, those all files has to be traced out. And also, any exams were conducted last,
Anyway, 1 week.
yes, once,
Dear lawyers, just 1 week. Monday.
But the fact that I have taken it.
Yes.
And the, it will be the senior person.
that also have instruction. Maybe they have not. But
This time,
communication to other, I don't have.
this time
I'm sorry.
this time seek serious instruction because the senior assistant personnel, senior assistant, senior personnel is all over.
Yes,
Say all the same thing unless you decided in a very, I mean, reasonable ground with reasons that they cannot be conducted. So Monday, 1 week. Not Mr. Deepak, but also to be. Then first. This, considering the grievance raised in this petition, this court, while issuing notice on 04/07/2025, directed the then Constable APTSC to obtain instruction. However, no instruction is said to have the 11 state constables submitted that they not received instruction yet. Considering above, this matter to be state on Monday, 25, 25 on which they the legislative council will obtain, they place the instruction. Considering that the similar post which was senior person, senior, the other post. Senior person system. Which was put on hold.
Yes. By the same.
Postpone or what? Don't know what do you want? Postpone. Along with the post in question. That already settled by. Has been conducted, interview has been conducted. That also I don't have. That is the investment. Settled. Not my. Anyway, Monday.
Item
Then the matters and the
Who is for service concern? Then they start performing better. Unfortunately, same things are happening.
that has
Such better instructions to coming so late, that's unfortunate.
one sided.
Same things are again going.
Item number 23.
I am the petitioners in this case.
Yes. So,
So everyone is ready to the, my lord, matter may be disposed of. This is a case of
what is the time? Huh? What is the matter? The arbitration, one sided, PI interested, several the arbitration. Said what?
in this case, Your Honor, PI was supervising the arbitration proceeding
Ah,
that at Srijusa. And matter was regarding land dispute between the parties. And arbitrator were also appointed by the CEO, that is on behalf of ADC Srijusa. So the writ petition has been filed challenging the order of appointment of the arbitrators arbitrarily by the ADC Srijusa. And moreover, arbitration proceeding was, from the very beginning, it was supervised by the PI. And it was submitted by the PI. And judgment was also done by the PI himself. So, in this case, I have a judgment in which the PI and Gambras is the judgment in the appeal in the Tadik, Tabang, and others passes, Kumjo, Angu, and others. Here in this case, the duties and power function of the PI was made clear that it was only to assist the pledge authorities in the resolving the dispute between the parties. But in our case, it was the PI who have supervised. And 2 points, my lord. That is illegal appointment of arbitrators. Arbitrators should be appointed equally by the parties themselves. But in this case, it was appointed by the ADC. And moreover, PI has no role to play. But here, PI was made like a judge.
yes.
So,
Yes, yeah.
Lordship, I am in this case appearing on behalf of private respondent number 6 and 7 also. Lordship, actually,
Which section 7?
6 and 7 is, Lordship, I am the actual owner of that land,
Okay.
which is claimed by the petitioners.
So he has raised a law point. What he said is that PI has no political interpreter, has no role to play. His only job is to assist.
Lordship, if they are not satisfied regarding that decision of the Kewang, Lordship, then Lordship, they have to go as per provision of appellate court. That is section 46, Assam Frontier Regulation Act 1945.
I think it's no longer there.
Lordship, this matter was filed at that time, 2020. Lordship. So
Then when the law itself, the judgment order itself is honest by an authority without any jurisdiction, it's as good as honest. Can be interpreted.
Lordship, it goes
See, the appeal will provide, appeal will lie when the authority having the jurisdiction and the authority to pass order. But here is a case, the authority who has decides the matter has no jurisdiction and authority. That is what is submission.
So, your Lordship, Lordship, next thing is that, Lordship, my prayers. This read is not maintainable. They have to go first, section 46 of clause 1. They have filed already application before the additional deputy commissioner. They have filed the appeal. Yes, already filed the appeal. So, that matter is still, Lordship, pending there. So, if there is first any negative order, they can approach
Yes, Kago,
civil. Yes, Lordship.
if you have filed an appeal, why you are filing a writ petition?
Yes, Lordship. That is-
Either you withdraw that and file a writ petition or you withdraw the writ petition.
Yes,
They cannot be two parallel proceedings.
yes, Lordship. That is the issue.
It is you to decide which is better to
Yes.
manage.
Exactly, Lordship.
What is saying that wrongly or rightly is a decision by the village authority,
Yes,
right? Therefore, appeal lies.
yes.
But then, without, by considering your submission that the PI has no authority and jurisdiction, may looked into it. But he said you have already filed an appeal. Either you withdraw that or you withdraw this.
Yes,
But you cannot have a parallel proceedings.
I'm ready to participate anywhere.
There cannot be a parallel proceedings. You may have a valid point. You may have a good ground. But you have to decide which remedy you have to. Because it's not that the appellate court doesn't have the jurisdiction. Right? Are you getting me? It's not that the High Court or High Court, the appellate court has equally a power to interfere with the order passed by an authority doesn't on the ground of lack of jurisdiction.
Yes.
Or lack of authority. They have the equal power.
Yes.
The appellate court. But technically, legally, you cannot have a parallel proceedings. Right? You take a call.
See your application, page number 45, in their petition itself is, they have annexure number 7. They said they filed appeal before deputy commissioner, advocacy against their village decision, village authority decision. The matter is still.
Number one, we have paucity of time. Number two, in view of this, you think about it. The grounds you have raised may have a valid ground to be examined and looked into. But then in view of this, you think about it, find out what is exactly.
Otherwise, matter may respond today itself because the matter kept saying.
Saying
5
what?
years.
Saying what?
Saying that the matter may refer back to the authority.
No. Either you withdraw this
Yes.
to only allow you to pursue the appeal, or you withdraw the appeal so that you can be, this matter can be decided by this court. That's a better way.
Time may be.
Time.
Time.
You decide on it. You see the appropriate forum. What he is saying that since there's an appeal provision, you cannot file the writ petition. It is barred, right? So if there is a appeal provision, appellate authority has equal power to interfere with the authority, the order passed to the jurisdiction or not. Heard Mr. No, and heard Mr. N. No, Mr.
In cargo.
N. Cargo learned counsel for the petitioners submits that in view of the appeal against the Keba decision. Keba decision.
Yes.
What is it? What do you call is Keba?
In yellow lordship in the civil
Yellow.
society is called as yellow.
Oh, yellow. Yellow.
Yes, sir.
Under challenge. Yellow. na?
Yes,
Y-
yellow.
and you-
YALLUN.
And in bracket, decision of the village authority.
Yes, sir.
Bracket close. Under challenge is has been it's challenge under challenge is pending in the appellate court. Appeal being pending against the decision of the village authority. Within bracket yellow. Papa. Sometime. Take a call whether to pursue the appeal pending before the appellate court. Appellate court below and or to pursue this matter. Mr. Irama. Titoku. And Mr. Titoku for respondent number.
6 and 7 lords.
Then you write Mr. Irama. Council wants to respond and Mr. Titoku for respondent number. 6 and 7.
Yes, sir.
Without any objection. Where what? This the matter after 3 weeks. 2 weeks.
First of all,
Item number 25.
May I please, Your Lordship?
Yes.
May I please, Your Lordship? In this writ petition, my lord, pleading is already completed, my lord. Matter may be fixed for final disposal, my lord.
Listed for final disposal only.
Yes, my lord.
Listed for hearing only.
Yes,
This
my
is
lord.
listed for hearing only, sir.
Yes, my lord. Another date may be fixed, so Lordship, another date may be fixed.
Sir,
I will
which is listed
appear physically, my
counsel
lord.
for the petitioner and prayer not being objected to by Mr. M. Kato Learned DSL.
Lordship, on 1st
That is better be
September,
listed after.
on 1st September, if possible, my lord, I will come physically.
This matter being listed on first 09
First
0109.
Lordship, first is holiday.
Huh?
On first it's a holiday.
When?
1st
Second.
September, my lord. Or 2nd September.
It is holidays, sir.
Lordship, or
What
8th
is
September. my
holiday?
lord.
Huh?
8th September, my lord.
8th
8 September.
8th
huh?
September. Yes, my lord.
September.
Most obliged, my lord.